Otherwise, my lord, item 10, 11, 12, and 59 of the supplementary list, my lord,
They are also same.
all take, my lord.
11 and 12 are
As averaging of the same FM.
Same affair.
CD has come.
City has.
Yes, come. So when do you want? When can we fix it?
Next week, my lord.
Next week.
My lord, I appear for item in item number 10. We are appearing, my lord.
11.
10, my lord.
Except item 12, my lord. They are appearing, my lord.
10, 11, and 59, my lord. We are appearing. We are not seeking adjournment.
Yes.
We file an additional.
Only item 12, my lord.
We can do one thing. 1 week will be, I think, a little inconvenient. So something like Wednesday, and we can dispose of the other matters.
Yes, my lord. Wednesday.
Wednesday.
Yes.
12 Wednesday. CD will be retained. That's
Simply.
Lordship, in item
others will take.
10, 11, we have filed one additional. If you can, it may be called for, my lord.
Yes.
May it please your lordship. Lordship, I pray for listing of the anticipatory bail. Be listed tomorrow, lordship.
No problem.
Day after tomorrow, lordship.
As you wish.
If I beg to mention item 49, it was actually fixed on 8th of January 2026, but it has wrongly come up today. I think case diary is also not available. I'm on interim. 49.
Diary is there. 49.
Yes,
49.
Lordship.
Is there is not received. It is submitted that perhaps it is wrongly listed today as the date was
8th of January.
direct to be fixed on 8 January. So list the matter. Issue fresh requisition for the case diary. List the matter on 8/1/2026.
Interim.
Interim bail shall by order dated so and so shall stand extended.
May I please, your lordship? Lordship, I beg to mention item number 33, lordship. 33, I believe the case diary has not been received, lordship. Was called.
33 CD not.
Case diary is 33. Issue fresh requisition. Interim.
Lordship.
Interim shall stand extended till the next day. Is the matter when should we fix?
9.
Hmm?
9.
9/1. 9/1.
May I please, your lordship?
Deeply obliged.
May I please? I beg to mention item number 43, my lord.
Hmm?
43, my lord. Can this matter be taken after vacation, my lord? Case diary has not been received, my lord.
43. Issue reminder fresh requisition for the case diary. Interim is there.
There is interim.
Interim extended till the next date. List on 9/1.
Obliged.
May please, your lordship. Lordship, I beg to mention listing an AB lordship today, lordship. Because out of same FIR, lordship, one matter has already been listed
Listed today.
Item 19, lordship. Obliged.
May I please, lordship? Lordship, I beg to mention item number 27. Lordship, CD is not available. Interim only. Continued, lordship.
CD is not available. Adjourn it. Interim is there.
Yes.
Just a minute. Take the date. Sure, no? Not received. Not received.
Item number
27.
27. CD not received.
CD issue reminder for CD. Case diary. Sorry, that's interim bail stands extended till the next date. This is the matter on 8/1.
Yes.
8/1.
Obliged, lordship.
May I please, lordship? Lordship, I beg to mention item number 15 from daily list. This matter may come up on Thursday.
1/5.
1/5/15.
Scan record probably is received. You want it to be fixed on
Thursday, my lord.
Thursday. 6 and adjourn. List on Thursday will be which date? 11.
11.
11.
May I please, your lordship? Lordship, I like to mention item number 8 of the daily list. Lordship, CD is not available and interim may be continued.
Your interim is there?
Yes.
Interim is there. Case diary is not available. Issue fresh requisition. Interim bail by order dated so and so shall stand extended in the next date of listing. When should we fix?
Lordship, January, lordship.
10/1.
Obviously.
May I please, your lordship? Lordship, I beg to mention item 40.
40.
Oh. Due to my senior's illness.
Just
Kindly list the
Scan
matter
record is
after
there.
vacation.
interim is there.
May continue.
6 and adjournment, can we have it before vacation?
After,
Submitted that the leading counsel is unwell and praised for fixing the matter in the first week of January. Scan record is available. Interim order is there. Interim order stands extended till the next date of listing. This is the matter on 8-1.
May it please your lordship, I beg to mention daily list item number 18. My learned senior F. Hussain is not well. So lordship kindly pass over the matter for the day.
The ground
18.
of the leading counsel being unwell, matter is adjourned for the day. And when should we fix it?
Any day, lordship.
Next Monday?
Lordship.
Next month. No, not next month. 16th.
Much obliged.
May it please your lordship. Lordship, I beg to mention item number 53, lordship. Lordship, kindly fix this matter after vacation, lordship. Lordship, we have taken the consent of the other side and the council is present.
They submitted that with the consent of the other side. The matter may be fixed after winter break. Having the prayer. Any suggested date from your side?
Lordship,
8, 9.
convenient to the court, lordship.
8-1. 8
Obliged, lordship.
2026.
may I please your lordship, I beg to mention item number 6, your lordship, kindly matter may be taken on 11 December.
11 December. Item 6.
Yes, your
Right.
lordship. And your lordship, item number 26 CD.
Just a minute. Huh? 6. On prayer for adjournment, list matter on 11th of this
Yes,
just 6. And what is the other one?
Item number 26, your lordship.
26.
CD has not come.
I'll come. 26. CD has not come.
Yes, your,
CD not received. Issue reminder. Interim is there.
yes, your lordship.
Interim extended till the next date of listing. Suggested date. What are good? 7-1.
Oblige your lordship.
Till.
Your lordship, item number 28.
28.
CD has not come
Another day. you want?
and in terms maybe extended.
Interim is there. Let us give it same then. 7-1. Same order. 7-1.
Oblige here.
May I please lordship? Lordship, item number 30.
20.
30.
30.
My senior is out of station, lordship. Matter may pass over for the day.
Interim is there. Interim order is there.
Item number
Any interim order is there?
No, no.
You're not sure. Interim orders are
CD received my item number 40.
it is received. Let's have this week only.
please, lordship.
So let it be on Thursday. CD is received shall be retained. Council 6 adjournment due to the leading counsel being unwell. Is the matter on 11-12.
May I plead your lordship? Your lordship, I would like to mention for listing of a bill application, your lordship. It was last listed on 2nd of December, your lordship. However, it did not reach your lordship. Kindly, your lordship, the matter will be listed on next week. Any date?
This week? No problem.
I love it.
Kindly check this one.
Your lordship, a date may be fixed, your lordship.
Date.
Yes.
The date. When do you want it? 12, 12, 11, 12? 12, 11.
Your lordship.
11.
11. Kindly of that.
Want to withdraw? Your good name, please.
Yes, Islami.
Yes, Islam, London. Council. 6. Withdrawal of the matter on instruction. Allowing the prayer, comma, the instant bill petition is disposed of upon withdrawal.
Pass obliged.
Item number 1.
May I please your lordship? Last time CD was called for, along with FSL report and postmortem report, my lordship.
This matter has been wrongly listed for motion, my lord. It has been listed for my lord bail hearing.
There is no order of calling for CD. Yeah.
In this case, I am appealing for the informant.
On the prayer of the Is it the right matter I'm taking? 3-7, right? Apurva Malik, Apurva Malik.
Wrongly mentioned.
Oh, on prayer, last only order is there of 1911 on prayer of comma. Release the matter on 8-12.
Oh, yeah. I thought my lord CD call.
CD is not, but CD has come.
No, my lord, CD not received.
So
Yeah, I think for information. Yeah, I don't think. Will find the club. Our name.
you file on objection already.
Objection order. Lordship, may I pay for 1 minute to make a submission?
Yes, sure.
Lordship, here's what happened, my lordship. The last time FSL report and postmortem report is called for,
Not
and
all.
No,
just
this-
make my submission.
Yeah.
So when the FSL report and the postmortem report will come, it will reveal the whole truth, unearth the whole truth. The whole lordship, if it is a case of suicide, my lordship, and even assuming but not admitting this fact, it's a victim of suicide. So ultimately, maximum punishment will be 10 years. If it is maximum punishment of 10 years, then 60 days will be the statutory period. So in the meantime, statutory period will be over, my lordship. So lordship, kindly give it 2-3 days CDO call. Here is only from CDO will come from this position, K3, from here only, 50 kilometer distance from this
K3.
honorable court.
Anyway, that's okay. But there's no order calling CD, so
Yes.
we'll make the order. Third Learned Counsel, your good name, please. Your good name, please.
Aramin, my lordship.
R. Amin. For the petitioner, additional PP, Port Harcourt, and Learned Counsel enters appearance for the informant. She's for the informant, not impleted, but informant. The case. All for the case diary of K3 PS case number 92 of 2025, along with PM report if available.
And
Stop. You have filed a written objection or you filed?
Lordship, may I file the objection account of objection?
The informant side has already filed a written objection. And the petitioner counsel seeks permission to file a reply with comma, which is allowed. In the meantime, you file it.
Yes,
Fix it on Friday,
this Friday, lordship.
this Friday.
And my lordship, along with FSL report, my lordship.
FSL along with PM and FSL report. If
FSL.
it's available,
Fingertips will be.
then we'll bring it. No problem.
I'll
the
your
man-
place, my lordship.
12.
Lordship, FIR at page number 10, my lord. Operative part, page 12, my lord. For 73 days, she is behind the bar. Page 12, may I read, my
Page.
Page 12, 1-2, my lord. That the com comprise of Sain Tularam Reji Haflong introduced Atawur Rahman at Haflong, and since then I know him. That on 4/12/2024, the accused person approached me to lease one kata for installation of BSNL tower from my Patta land, and also gave me the responsibility for installation of 100 numbers of BSNL tower within Jemin and Dimasa population area of Dima and Narkachar at 14,000 per month of each BSNL tower. The accused Atawur Rahman on behalf of the Bharat Sanchar Nigam made an agreement on 5/12/2024, which was prepared by the accused and also taking the signature of second party. That I have not seen the second party till date. The accused Atawur, after executing the agreement, have been taking money from me, giving different reasons. That the accused have taken cash amount of 1 lakh, 12 lakh, only through bank accounts of Atawur Nur Jahan Begum. Now, my lord, I am for Nur Jahan Begum, my lord. All along in the FIR, my lord, allegation against her husband, my lord, and she is behind the bar for last 73 days, my lord.
Let us, yeah.
Yes, yes, Lordship, kindly page 14, my lord. Ground number 2 during course of investigation, my lord.
Ground number 2.
1 and 2, my lord. one second line, my lord. Atabur Rahman and Srimati Noorjahan Begum has cheated many other innocent people from Haflong town area and also caused financial loss, not only. And second, my lord, ground also, my lord,
My lord, only thing is that the
by
account
providing
has,
forged documents in the name of BSNL tower
that
installation.
has
He's in
been done by
custody
us.
for 73 days.
My
He's in custody for,
73 days. And now, my lord, kindly have a
what are
look.
the sections?
Section, my lord,
Anyway, so when can we get?
my lord, kindly have a look, my lord,
Haflong.
page 1717, my lord. My lord, this is the second notice under section 47, my lord. My lord, recent judgment of apex court, my lord, the notice under section 47 is required to be communicated, my lord, in a language which he or she understand, my lord. Kindly have a look, my lord, this notice 47, she put her signature as in Assamese, my lord, Noor Jahan Begum, my lord. Even there is a note that it was explained to her, my lord.
So, diary will be necessary.
No, my lord, considering the recent judgment of my lord,
True, but when can we get
My
the case
lord,
diary?
my lord,
Let us-
Supreme Court has held that, my
On
lord,
15th,
Huh? Let us
15,
fix it on
15,
12. We'll
12
take a
weeks.
chance.
12.
Let's see I want to see the case diary.
now, my
The
lord,
amount
only
is very
thing is,
big.
my lord, by virtue of recent judgment, my lord.
That's
i-
true, but thing is that the grounds
In,
are
in
there.
that judgment, my lord, apex court held that, my lord, the detention and subsequent remand is illegal, my lord.
Anyway, see. The learned petitioner council submits that. Call for the case diary from the concerned police station. Case diary, Haflong PS case number 61 of 25, concerned police station. The learned council submits that the main allegations in the FIR is not directed against the present petition, who has already spent 73 days in pre-trial detention. Full stop. He has also drawn my attention to the notice under 47 DNSS and submits that it is in English language, though the petitioner as the arrestee at that time had put her signature in Assamese language. Stop. Is the matter on, when can we get it? 11th will be possible. 12th we jam.
Yes, 11th I will try.
11th, right? 11th.
Obliged.
Let's see. Tell me.
Lordship, in this case, instruction was called for previously.
I have
Because-
received the instruction.
Regarding registration of case.
Yes.
No case will register pending against the present.
No case is pending.
No case.
It's okay. The petitioner, the two petitioners herein, namely, three petitioners herein, namely, so and so, had invoked the jurisdiction under 482 BNSS with the prevention of arrest, though no specific details were available with them at that time regarding registration of case. Full stop. In this context, a report was called for, and the learned additional PP, Mr. B. Bhattakur, submits that as per communication received from the concerned police station, there is no case registered against the petitioners in the said police station. In view of the same, at present, the apprehension of arrest is baseless, making the pre-arrest bail application maintainable at this stage. Accordingly, it is disposed of. If there's some other development, then you can always file it.
Lordship, if possible, Lordship, can a further instruction may be called for if there is, since there is a complaint against the petitioner.
There's no case registered
has
against.
been-
There's no case registered
Yes,
against.
already report received, my lord, there is no case pending.
There's no case registered. You have
GD
information that case has been, complaint has been filed.
Yes, Lordship.
Complaint, probably they have not registered a case.
Maybe
Yes.
that's the GD entry, Lordship.
No,
If
if
that
they-
instructions were.
They have, my lord, always they have the right to approach again, my lord. If
That is true. That's why I usually prefer to call it like that. Any
Yes.
case,
Yes.
any complaint received or any case
Yes,
registered.
my lord.
That
But
covers
as
everything.
per report, my lord, there is no such case.
You want a further instruction?
Yes,
to be
Lordship, because if there is a GD entry, there is possibility that the case may be.
However, the learned council submits that as per their information, one complaint has been filed in the police station. And therefore, the praise for taking an instruction as to the filing of any such complaint and the corresponding GD entry. So Therefore, keeping this bail application pending, the learned OC of this concerned police station, Lanka PS, may submit a additional report regarding filing of any complaint in the police station and the corresponding GD entry. Actually, if the case is not registered, they will not be able to. There has to be a case to arrest you.
Yes, ma'am.
There has to be they cannot. There has to be a, maybe they are conducting some preliminary inquiry. Never mind. If you want, you call it.
That report may kindly be kept as a part of the record.
Or this report may be kept in the part.
And my copy of this order may kindly be served to me so I can
Yes.
cancel.
A copy of this order shall be furnished to the learned additional people. This is the matter on Tuesday, next
Yeah,
Tuesday,
yes, ma'am.
16.
Much obliged, Lordship.
16.
May it please your lordship. 438 application, my lord. FIR is at page 14, my lord. The informant happens to be a resident of my lord, Jagirol. Now he comes in and file an FIR in Sanmari police station. And these are two business partners. They have business conflict in between the two, and this FIR has been lost. The gist of the FIR is this, at page 14, that this Sushil Kumar Khandela got 3 work orders that has been mentioned in the chart itself with regard to carrying on construction work in BTC area. As per the informant, my lord, this Manoj Halalka has been given power of attorney to execute the work. And because of that, that conflict arises and allegation has been made that he opened a fake bank account in Federal Bank, Bongaigaon. And thereafter, after execution the work, the security deposit has been taken, put in that particular account, and this petitioner has misappropriated. This is the sum and substance. My lord will kindly come to all offenses here, my lord, are punishable 7 years and less. So, my lord, at page 19, my lord will kindly see. Whole dispute arises with regard to this execution of work, which I have to execute it, these 3 work orders that find place in
Ganesh Trading.
Yes, Ganesh Trading, my lord. And these 3 work orders find place in the FIR also. Now, my lord will kindly come to my lord. That 33% at page 20. This is whole of the dispute, my lord. 33% of the profit earned by execution of work arrive at all expenses, including depreciation, work expenses, and all statutory so and so, so and so. For this purpose, my lord will kindly come to again a page, my lord, 22, wherein whatever are my expenses day to day in construction, I used to send him by mail. Now he is not giving me back this money, and for which, my lord, he lost an FIR with regard to this. All this page 20 to 28, my lord, are my dues, which I have spent from my
Regarding
pocket.
the expenses.
Yes. At page 29, my lord will kindly come that notice under 35.3 of the BNSS has been provided to me through Bongaigaon police station, my lord, where the date was, my lord, on 29/10. It reached there lately, my lord, and I was in Delhi, my lord, in connection with some nephrological problem at page 30, my lord. And as such, I couldn't appear as per the notice, my lord. Why I am apprehending arrest, that is very important, my lord, in spite of the notice, is this, that the informant happens to be a resident of Jagi Road. He doesn't lose an affair in Jagi Road. He doesn't lose an affair in Bongaigaon. He lost an affair in Sanmari because one of his good friend is a police officer there. And expecting foul play, I am apprehending arrest with regard to this. And I am ready to provide my specimen signature and everything, my lord. My lord very well knows, if I open a bank account, my lord, all checkbooks, all ATM card is been received at a postal address at the residence, not somewhere else. So he said that
A registered address.
absolutely registered address, and registered address is Jagi Road, my lord. So he received everything. He issued check. Now he is disputing it. And it's incumbent on the part of the bank also, before clearing any check, to check the signatures. And thereafter they, my lord, cleared the checks.
Hmm.
So this is nothing but an afterthought, my lord. I pray that I may be protected in interim, my lord. I will cooperate in the investigations.
Let me see the agreement.
My lord, allegations are very serious. Your lordship may
Let me
kindly
see.
come to that, my lord, work order, my lord, in the name of the informant, my lord.
Yes,
Thereafter, forging his signature. Thereafter, my lord, those amounts, opening of the forced bank account. Thereafter, my lord, transferring all those amounts in his own bank account, my lord. Thereafter, misappropriating. Your lordship may kindly come to, my lord, page 15. First portion is the, my lord, one Sri Manoj, page 14, my lord, second line. One
Yes,
Sri.
I want to go through the FIR complaint.
Yes,
Just let
page 15, my lord, regarding inquiry, my lord.
let me see the
Third
agreement.
paragraph, my lord.
I'll see the agreement. I'll read it on my own.
yes. Page 15, my lord, will see his address.
Yeah, just
Yes, page 50. His address is Jagirao. He comes in Chanmari police station. Work order kita sir. Intaeki. Ekita work order sir. He opened his bank account in Federal Bank for that work can be carried out smoothly, my lord. And he is the author of this particular bank account, my lord. It is in his name. He has opened it. He has provided his phone number along with my phone number also, being business partner. That I have clearly stated in paragraph 5, my lord. Paragraph 5 of my petition, I have clearly stated.
I'll just
Paragraph 5. Sir.
okay. You wanted to show me something? Para 5, what you
Para 5, yes, I have gone through that, my lord. That account was not run by the present complainant,
No.
but run by the, my lord, accused person, my lord. How that happened, my lord, it
Cannot be.
said. But thereafter, my lord, second line, my lord, sixth paragraph also, my lord, after receiving amount opening from Federal Bank, it was
All has
found
been
that
seized, my lord, in
Manoj
connection with
Hardikar
this case.
deleted my signature from joint signatory column by using whitener. And how that can be done, my lord,
Definitely,
in a bank document, my lord?
Third, also petitioner and petitioner PP Bothago. The projected facts these days are that the present accused petitioner and a representative of Sushil Kumar Khandelia, the informant, right? He's the
Yes, he's the informant, my lord.
on behalf of his firm, Ganesh Trading Company, entered into an agreement dated 27th 2013,
Yeah.
whereby the present accused petitioner was given power of attorney with regard to execution of 3 contractual works that had been secured by the petitioner firm and the informants and which were to be executed at they had to be executed at
BTC, my lord. Area.
BTC area.
Most
The present
precise
accused
is,
petitioner is based in
Zagi Road.
He's based in Jagi Road.
Yes, informant is Zagi Road and petitioner is from Bongaigaon.
The informant is based in Jagi Road and the accused petitioner is based in Bongaigaon. The same also is revealed from the agreement. Subsequently, with some allegations, the informant, who is the proprietor of Ganesh Trading, the aforesaid Ganesh Trading Company, lodged an FIR dated 8/8/2025 in the Chanmari police station. The gist of the allegation is that in the context of the accused petitioner been given the power of attorney with regard to the construction works as mentioned above. He fraudulently withdrew and deposited the security deposits and maintenance deposits belonging to the firm in the context of these works. The misappropriated amount has been mentioned as much as 1 crore 48 lakhs 95,839. The learned counsel submits that the dispute is civil in nature and that as part of the execution works, the accused petitioner incurred many daily expenses for which the informant was to pay him but has not done so. He has drawn attention to one annexed document in this regard. Petitioner seeks interim protection and submits that he is willing to record his statement. The additional PP submits that the allegations are serious in nature and the amount in question is also huge. It is also submitted from the petitioner side that the informant has unfairly filed the FIR in Chanmari police station without invoking any jurisdiction in Jagirot or Bongai. Call for the case diary from the concerned police station. Chanmari PS case number 204/2025. I have given my anxious consideration to the prayer for interim protection. The allegations are undoubtedly serious and the amount in question is on the higher side. Nevertheless, the dispute does seem to have one civil dimension as well. It is well said that such a dispute can have both a civil or a criminal dimension. Therefore, I am of the considered view that allowing the accused petitioner to record his version of events could be useful to the investigation. Recording in the event of his arrest, 50,000 with one security of the like amount, the satisfaction of the arrest. Okay, 50.
Deeply applies.
One security of the like amount, the satisfaction of the arresting authority, and subject to the condition that he shall render full cooperation to the investigation. Number 3, he shall appear before the IO, making himself available for examination. He shall not in any manner hamper or tamper with evidence. Violation will entail cancellation of the interim. This is the matter on Tuesday,
8th of January.
8th of January.
8th of January.
Then after Bihu vacation, needed on 19th of January.
Deeply obliged.
8th of January.
8th of January.
Deeply obliged.
Because we don't know now what's that.
Yes.
Yes.
8-1.
May I please, Your Lordship?
Yeah.
My lord, here in this case, my lord, the petitioner is apprehending arrest by the police of Hado PS, Your Lordship.
Hajo PS.
My lord, the petitioner has come to know some FIR is lodged against him, but he could not find out any registered FIR.
I will get a report, man.
My lord, some protection may be given.
Invoking
I will appear before the
jurisdiction
Hado.
under 482 BNSS. The petitioner is apprehending arrest by the police within the jurisdiction by the police of Hajo PS. However, he does not have details regarding any case at present. A report may be called for from the concerned police station as to whether any FIR, whether any complaint has been filed against the petitioner and whether any case has been registered there. The connected GD entries, if any, may also be furnished in the report. Right. Let's get that because now it will be a land bank order, right? Coercive measure, what is open.
Right.
We don't know.
It is difficult at this point of
Fast,
time.
but actually it's
Difficult to say.
we do not know.
But police is asking me to appear before the police.
Any short date on Friday also, I can put you get the report.
Coercive action may not be
Because we do
taken.
not even know what is the case. Anyway, so allowing the prayer of the petitioner in this regard vis-a-vis his apprehension. It is directed that till the report is perused and till the report is received by the court, the present petitioner with regard to any such matter in the Haju PS shall not be subjected to any coercive measures. He is at
But-
liberty to appear before the police station
My lord, much
for the
obliged.
needful.
Obliged, your lordship.
This is the matter on, when should we get the report?
On my lord, on 12, my lord, it would be on 5th of January. 5th of January.
Much obliged.
We'll get report.
May please, Lordship. Lordship, this case is registered under section 309 subsection 4 of BNS. Lordship, in this case.
309.
Yes, Lordship.
What is that now?
309 is related to robbery, Lord.
Hmm?
Robbery.
Robbery.
Yes. This instant case, the investigating officer
Oh, gold chain was snatched.
yes, Lordship. He prayed for a shown arrest of the present petitioner. Since he was arrested in a different case, that is Patasi Lambari PS case number 131 of 25 under section 3042 of BNS. But in the meantime, he was released on bail. For that purpose, he is apprehending arrest as of now, Lordship.
In connection with this matter.
Yes, Lordship.
The allegations are, but it's not named. Yes, what do you say?
Otherwise, at this stage, investigation is going on. Earlier also,
allegations
earlier
My
also
gold chain was
petitioner
snatched by a
is-
boy riding scooter.
Yes. These are my lord serious offenses.
True, but he's not named in FIR.
Yes.
That's the only thing in his favor at this moment. Otherwise, we should take these things seriously,
Yes.
relating to public safety,
Yes,
especially women.
So it seems that he is habitual, but earlier also, my lord, involved in
Any matter.
Patasi Lambari PS case number. Although in that case, my lord, production warrant issued on 26/9/25. My lord, also IO has prayed for a showing priest.
Noyan
showing arrest, my lord.
Sarkar.
But only on the basis of suspicion, Lordship, this
Reported
case
he was
has been
granted
registered.
bail in that case now.
Maybe. Because of his involvement, he may be, and because of suspicion also maybe. But he's not named
Yes, Lordship.
anyway. But these are serious matters. But anyway, let him record his statement. But these are, we should take it, fix it before vacation.
Yes.
Your good name, please?
S. Yasmin. I'm appearing on behalf of D. Meeting.
Yes, Yasmin, learned counsel. And keyboard Thakur, invoking 482 BNSS, the two petitioners seeking bail in connection with Jalukbari PS case number 391 of 25. The case arose out of FIR dated 15/9/25, lost by Pronita DP with the allegation that on that day in the afternoon, one boy riding a scooty and wearing a blue shirt snatched her gold chain from her neck at Maligaon Charayan. The learned additional brief he submits that perhaps there is involvement of the present petitioner in other cases as well. The petitioner counsel submits that police are seeking him out solely on suspicion. But they have records of these things. They will suspect him. Considering that the petitioners are not named in FIR, they can be given an opportunity to record their statements. Call for the case diary of Jalukbari PS 391 of 25. In the meantime, the petitioners, in the event of the arrest, 25,000 once they appear before the corporate investigation here, and say they shall not misuse their liberty to commit any offenses or illegal activities. Violation will entail cancellation of the interim. This is the matter of 16
Yes,
explain. Otherwise, it should have, it sends a wrong message also. Let him record.
well, in this type of offenses, initially, definitely
Public safety matter.
all are unknown.
Public, yes,
Yes,
it's not possible to name the
Possible.
person. Therefore, ideally, TIP should be done
Yes,
in some case, but it's overloaded, not possible. It's 6 days. Anyway, let him record the statement. See, he's not named.
Much obliged.
Nine or one. Oh, take me. And it will all be. Sir,
number 10.
Yes, your lordships,
surrendering issue, no?
yes, surrendering issue, I've already interim bail till today. And your lordship, if you go through the merit of the case, my lord, by this time already 66 days he's in custody. So that time period is over as per 138/87 BLSS. He was shown arrest on.
I've not found, I never found a case on this. But logically, if a person is on interim bail, interim regular bail, what happens to the statutory period?
Yes, yeah,
That is still counted.
Yes, well,
Out
otherwise,
of 60 days.
I have calculated up to the date of arrest,
No,
up to the date of.
Suppose he's on interim bail for 40 days out of 60 days. Then at the end of 60 days, will he be
Suppose, my lord,
statutory bail? I'm
sup-
looking for a judgment on it.
yes.
But I've given bail actually because I've not found.
Here
the
the
contrary.
case is slightly different because on the pretext after getting interim by all the petitioner, there are all to tell, my lord, there are many 11 numbers of cases, my lord, against
That
the
is a
present
different
accused
issue,
person.
but in this
But
case,
here in the present, my lord, here, my lord, today, my lord, there are 3 cases, my lord, against the present petitioner is before your lordship, my lord.
Same petitioner.
Same petitioner, my lord.
but so far this case is concerned,
And
they have
my
not filed any charge sheet. So last per law,
Suppose, my lord-
but the other case may not be get. He may
Suppose, my
not
lord, in
get.
all these cases, petitioner obtain interim protection only on the medical ground, my lord.
Hmm.
Suppose if, my lord, without violating the order of this honorable court, if petitioner immediately surrendered, then today also, my lord, I would have been said, yes, petitioner obeyed the
But he has not
honorable
surrendered.
court, but he has not surrendered.
No, that's what I given an affidavit, my lord. I was specially instructed to give an affidavit.
You're seeking extension.
I have seeking extension, and at the same time, my lord, since it is a case specific, this is a case that we have that beyond jurisdiction period they have not submitted charge sheet, and he is in custody period is 66 days. So technically, he should.
He's not in custody. He's in bail.
No, he's in bail. No.
So
My-
that is why
my-
kindly. No, I'm saying, that's why I have given bail in such situations because I have not come across a judgment which says that this period has to be excluded.
Yes.
But logically, it should be excluded, right?
Yes.
You're not on
Eh,
in custody.
Yes.
No, my lord, my submission, you just show, my lord, you're just saying, but my date of showed arrest on 18/8. And and I released on 23/10. So already that time, already 57 days is there.
57 days.
Yes. After that, 66 days over now.
18/10/2000.
15, 18, shown arrest on 18/8 and released on 23/10. That's why
Well,
this is the way I've calculated.
Please look for a judgment. Youngsters, do some research. Because it is, it cannot be excluded also.
Hello, I would like to point out one aspect, my lord, your lordship.
Suppose a person is on bail for almost the whole period of the statutory period. So,
Yes.
it's possible.
Yes.
He may be
it's
unwell.
so
something.
unnecessary.
But in the meantime, statutory period is over. Investigation reveals adverse materials. Then
Yeah.
investigation is not completed. But
Yes,
there
yes.
are adverse. Suppose.
In that case, if that period, while the
Can he say that I'm in custody for 60 days, investigation not complete? He's not in custody. On
he is
bail.
not in custody, yes, my lord.
But
Because-
he's not in custody,
Because
my
on
lord.
medical ground, my lord,
But
he
I
has
have
also-
not found a decision that has to be excluded. I have not found. I might have missed, but I have not found. Anyway.
My lord, I would like to point out one aspect.
Since
my
I have
lord.
not found, the situation is in your favor.
My lord, here, today, my lord, item number 10, because all matters are
We'll take up
so I'm
together.
little bit confused, my lord.
Yes, yes.
Item number 10, my lord, that is, my lord, Bhangagor PS case, my lord. Bhangagor PS case, কিমান আছিলে আপোনাৰ? Bhangagor PS কিমান আছিলে আপোনাৰ?
ভাঙা পিয়াস
173.24. That CD not yet received, my lord.
CD not received, that is different issue, but I'm
No, I'm just,
pointing out a technical aspect.
But he has not, why he has not, he has violated the bail condition actually.
No, he has not violated, my lord.
He was supposed to surrender on 7, I think.
But interim bail is continue, my lordship, go to the order, my lord. If you lordship go to the order sheet, my lord, pay 112.25.
So nobody appeared actually, I think.
Nobody appears, interim order
Nobody
passed,
appeared. So we were
extended.
constrained to,
See the
extend
next
it.
set of hearing.
Nobody appeared, so we were constrained to extend the interim,
Extend
giving beneficial thing. Isn't
It's
it?
the interim arrest
So
and
he should have, something should have been appeared. Someone should have appeared. Anyway,
so in this,
I'm not sticking to that. So, but whatever it is, the present, we come to the present.
yes, madam. Now I have filed an affidavit showing that I was already operated. After that, post complication was there. I was referred to GMC. GMC, they advised me to go for surgery again. So, my lord, by this time, the technical thing I have just pointed. Yeah, but it is up to your lordship to decide whether I am eligible for bail or not on that ground particular. Because other cases there, I am not arguing about other cases. I'm just on the merit of this case. And so far, the merit of the case is concerned also. There is only one there. 420, only one section, 420. 420 is extended up to 7 years.
my lord,
So far 187 BNS said the 60 days when the investigation relates to any other offense. And for 90 days for the life imprisonment, not like other 162 or CRCC.
Actually, our order is also in a way incorrect because this order was this said that in the event of this non-surrender, the interim bail order shall be deemed to have been cancelled automatically.
yes.
Means we could not have extended. To that extent, our order was actually not correct. Anyway, thing can be done now.
So, my lord, prima facie violated this honorable court's order, my lord. Thereafter, in
What is the additional affidavit?
Additional affidavit, my lord. I have stated, my lord, in additional affidavit. 3151.
Can we take it up tomorrow? Kindly look up this portion of law.
yes, my lord.
Most probably it cannot be excluded,
yes,
but just look it up.
yes.
We can take it up tomorrow. All these
Well, all
the other matters, if they are different, we can take it up. Yeah, in one case, the CD has not come.
well, item number 10 and 12, those are, my lord, Bhangagor PS case number 173/25. Item number 11 is Hatigao PS case, my lord. Twelve already done.
June, 12 and June. 11,
The heard Mr. Learned Counsel for the petition. Case there is available.
Case diary, my lord, Bhangagor PS case,
No, this one.
Yes.
Bail, this one,
BA 3151, my lord, CD not available. Bhangagor PS
not available.
not available.
Case there is not yet available. Full stop. The interim bail was granted to the petitioner by order dated so and so on held grounds and was extended subsequently. He has filed an additional affidavit which is available in the record. Seeking extension of the interim on continued held grounds. peruse the annexed medical papers. The learned counsel submits that he was arrested in this case on 18/8/2025, and he was upon grant of interim bail, he got released on 23/10, right? 23/10/2025, constituting 57 days. And that in the meantime, 57 days.
66 days. By the time he released, it's 66 days.
18/8/2025 to
And
23/10.
23/10, 66 days.
18/8/25 to by the time he was released, it was 66.
60 days. There's no question of. No, this is
And
not
thereby
66 days.
constituting 66 days. So it was, these principles don't come then.
The principle doesn't come. That's what I'm telling you. This is not
They're
come.
discussing for nothing then. No, but this point comes sometimes.
But in this particular case, instead of giving him interim bail, you should get release the bail also.
I will
The
check.
charge sheet is already.
Learned counsel submits that the applicable statutory period vis-a-vis the sections, that is
187. BNS.
vis-a-vis the sections, that is 318 subsection 4. BNS is 60 days.
Still have to see, because in some cases, my lord, organized crime, that section was also added, my lord, in some cases.
That is in this case 420.
In this case, because CD is not available.
318 420. 318 420.
because
Why you are mixing all the case together? Come to the one particular case. This case I am asking. Why you mix
So
and jump all the case?
because CD is not available with me, so I will have to go through the CD. Get
Yes, that's true. But I think in this case, only section is 318.
318, yes. That is the thing.
So probably he had completed the period.
At the time of granting interim protection.
So
So I will have to check, my lord.
we'll have to allow.
Your lordship may fix all
No,
the matters.
No, I think this has to be allowed, I think.
Yes,
He
yes,
had
that's the
already
thing.
completed on the at the time.
Then
of
your
release.
lordship may kindly record that, my lord, at the time of, my lord, granting interim protection, as per the submission of the
I've recorded.
statutory period, my lord,
I've
already
recorded.
completed. His statement may be recorded,
I've recorded.
and no other section added. So as per my knowledge,
Does,
because CD is not available, my lord.
Thus, it appears that even at the time of being granted interim bail, the petitioner had completed the statutory period of 60.
So, my lord, at the
It is-
time of granting interim protection, why that, my lord, aspect was not pointed out?
That is the other council. They are.
If, my lord, on that day, my lord,
That particular council he might have taken this point. I have noted. I am newly engaged council.
It's okay, you must be right.
because at this point of time, he is in interim protection. So, my lord, I will check tomorrow, your lordship, already.
No, my lord. No.
He is under protection, my lord.
He's on interim protection.
So, my lord, fix
Check.
tomorrow, my
Tomorrow
lord,
day
everything,
after.
I will check all this.
The learned additional PP seeks some time to. What will you check? Cross check.
Yes, my lord.
The status of
That's on the day of the interim protection, whether that statutory period for
Yes,
filing
you
such-
check it. It is
Cross check.
clear in your.
The factual matrix with regard to the detention of the petition. Prayer is allowed. The interim bail stands extended to the next date of listing on Wednesday.
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 Because you will take some time.
10.
Then item number 11, my lord.
Just a minute. 18/8. But even if it is added later, it will not help, no?
Yes, my lord, then I will.
So he was granted interim bail on 14/10.
Okay.
Yes, 1410, that till that no charge sheet was filed. After if they file charge sheet, then it will not affect.
No, you said that he was granted interim bail on.
Release on 2310.
On perusing the case record, I find that the petitioner was arrested on. He was arrested on
For 18/8.
18/8/2025 and forwarded on the same day. And the interim bail was granted on 14/10/2025. You said he got released on 23/10
2310, yes, 2310 he was released.
after 7 days.
After 7 days.
But
Even if that period counted, only 50 days was there.
In this context, the petitioner counsel reiterates that the petitioner got released on 23/10/2025 only.
My lord, my lord, in that earlier, my lord, in the morning, my lord, item number 12 that was mentioned, my lord.
Mhm.
Here that in that I have found one report of the IO, my lord, regarding item number 12. I'm sorry, your lordship, but because in that case, Bongagor PS 173/24, my lord. Here in this case, my lord, I have a report regarding filing of such check, my lord.
Mhm.
And in this case, my lord, CS number 116
Which
of
case?
this is my lord, item number 10, my lord.
No, this is item number 10.
10, my lord, because
Where
10
it was
10
filed,
is
sir?
my lord same with item number 12 because 12 was earlier mentioned, so I have not, my lord, noticed that.
No, it is always a little difficult to adjourn
Yes,
because without seeing the file, sometimes
yes, my lord.
there will be mistakes will creep in. Sometimes it is difficult. Anyway, so this matter we'll
No,
take it up day after tomorrow.
Day after
And if
tomorrow,
possible,
yes.
get the CD,
Yes,
get
yes.
the case that it will help you.
Start sheet already submitted.
Otherwise, it's okay. I understand.
Yes.
All right.
Yes.
So 10, item 10, fixed on
Wednesday.
10, 12.
10.
Next. 11 item.
11. 11, my lord. This is our 406/420. Custodial period is 50 days, and he was shown arrest on 8/10. And he was shown arrest on 8/10. And my lord,
Same hell grounds.
hell grounds. Only thing is that I want to argue whether 406/420 can be attract together. That point I want to raise.
They cannot be charged together or convicted together. At the stage of charge, whatever little I know is that the court has a discretion charging joint charges, framing charges under both will be wrong. But the court can frame alternative.
Alternative charge.
But because both cannot go together.
And my lord, so for the
Whether it can be registered under both, that I'm not sure.
It is registered under both 406/420.
Initially,
And another thing I want to point out, my lord, this FR laws on 28/25, and they have filed a charge under section 40420. That time already not in force.
Just a minute. Item 11, it is Hatigao case, right?
Hatigao case.
We'll mix up otherwise. It is
28, yes.
Hatigao case. 6 of 2025. He was shown arrested.
He was shown arrested
on 8/10.
28, yes, 8/10. In that case, how for he just filed charge sheet, I don't know. Because 406/420, that time it will not lie. Because that time already BNS comes into effect.
In this case, CD available, charge sheet not submitted, Hatigao PS.
But this itself is wrong. Framing a charge itself is wrong. Not framing charge.
Yes, search premium.
Registration 406/420. It's wrong.
Because sometimes at the stage of investigation,
Yes,
things
yes,
may not be
yes,
clear.
my lord.
So maybe
At the
you
time
can
of
give a
framing
benefit.
charge, if the same mistake occurred, then it can be said
We have
that.
to look for a
Yes.
case law, if any. The Delhi Race Club is clear about final conviction.
Yes.
Finally, person cannot be convicted under that is the leading case, Delhi Race Club. But whether it will apply to investigation, that we have to see. Read that judgment again to understand, or look for something else.
So in that aspect, I don't want to argue because I just want to argue on this point whether 406/420 is applicable or not together. They have filed.
I'll come to just give me.
Case there is there, no?
Case there is. Hatigao PS.
It can be disposal made or people.
This, my lord.
Order date is 16/10. 16/10 or 2, 3. Same. On 16/10/2025, the petitioner was granted interim bail primarily on medical grounds and to enable him to undergo a surgery as projected at that time on the basis of submissions and next documents. Full stop. The same was subsequently extended. In this case, the accused petitioner was shown arrested on 8/10/2025. And as already mentioned, he was granted interim bail on 16/10/2025. Oh, you're saying that FIR is of 8/10. So how can IPC sections be given? It's a mistake. The learned petitioner counsel submits that firstly, the FIR is of October 2025 when BNS was already in operation, in force, and the case was registered under section 406/420 IPC, and that secondly, as per the settled law, the offences of cheating and criminal breach of trust cannot go hand in hand. Good stuff. Case diary is received.
Case they received, my lord. Regarding the present, my lord, present petitioner, although that, my lord,
In this case, statutory period is over.
no, my lord, he is in interim protection, my lord. In this case, my lord, initially he obtained interim protection in one of the case because many cases pending against the present accused person on held ground. Thereafter, by taking that order, my lord, similar, my lord, order, he got in all these bail, my lord, petitions.
Health will be same.
Yes. Otherwise, my lord, regarding the present petitioner, there are total 11 numbers of cases, my lord, pending against.
11 number of cases.
Yes, 11 numbers of cases. Modus operandi is same. On the pretext of, my lord, thereafter, initially, my lord, taking over the vehicle, thereafter, your lordship in Lotus Hill PS case, my lord, I will point out to your lordship later on. And here also in your lordship, in the forwarding report, my lord, total number of cases pending against him, my lord, those all these, my lord, Pan Bazar, Bosisto, Sanmari, Polton Bazar, my lord, Rongia, Patasar, Kusir, everywhere, my lord. Same modus operandi, my lord, the same. And here in this case, my lord, this is not 60 days offense, my lord, 111(2) of the BNS is also there, my lord.
Where added subsequent.
Yes, my lord. This section is.
The case diary has been received as submitted by learned additional PPP Portaku. Full stop. It is also submitted by the learned prosecution that subsequently the police has added section
111(2), my lord.
111 subsection 2 of BNS pertaining to petty organized crime.
Yes, organized crime, my lord.
Petty organized
Not
crime. or
petty organized crime, my lord.
Petty organized crime. So this is organized crime. 2, section 2. What's the punishment? Organized, pertaining to petty, no, organized. crime.
Subsequent loga hai bola. But subsequent,
And it is submitted that the applicable statutory period with regard to the added section would be 90 days.
my lord, so far, if I gone, if they added 111, my lord, then I argue, how the 111 will attract? It should be a syndicate. The word syndicate is there.
As much as 11 cases are pending,
Yes.
prima
yes.
facie it could.
Syndicate is there, syndicate is
This
there.
is
He is
a
not,
member
he is not under member of any syndicate.
Initially, my lord, petitioner was arrested in Calcutta, my lord. Thereafter, my lord, on the basis of production warrant, he was.
The interim, the
Nick.
learned prosecution submits that the petitioner has been found to be involved in as many as 11 cases in different districts of Assam, where the modus operandi with regard to the alleged offences is the same. The learned prosecution opposes the grant of bail. He was arrested 8/10. So what is your submission? It should not be allowed. in
Oh,
this-
yes, my lord.
Can I have a look?
Yes.
The petitioner side has filed an additional affidavit seeking extension of the interim bail.
Government side is,
Health grounds.
PP side is always there to object. Whether your lordship will decide on merit,
My lord,
whether this section will attract in this particular case or not.
No, that depends on the investigation.
Yes, my lord.
That depends. on
They will always object,
investigation.
whether it is good or bad.
But I
They
am
will
saying
object.
this is a case for
someone
objection. my lord.
involved in this kind of modus operandi allegedly in 11 cases.
My lord.
My case of saying that organized
Yes,
crime will not
that
be
is
involved.
there, my lord. That I admit,
Yes.
that I admit, my lord. But your lordship will go through whether this particular section will applicable or not, 111 years.
And regarding next.
Later on they have
New
added.
section, to be applied correctly. So, yes,
Yes, my lord. Later on, I will point out in item number 59 everything, my lord, because I have with me the
applicable last order seeking extension of the interim bail on held grounds. Some documents have been annexed. On the documents, it is revealed that subsequent to the completion of hernia surgery, he was discharged and presently given conservative treatment. Kindly have a seat, sir. Sit
Oh,
down.
yes, sir.
You take 5 minutes to go to the. Before proceeding further, the contents of section 111 may be reproduced here in below. Section 111(2) subsection B is punishable with imprisonment not less than 5 years and which may extend to life imprisonment, and the person will also be liable to fine. Person will also be liable to minimum fine of 5 lakhs. This is a new provision inserted in the BNS. Full stop. So I peruse the relevant portions of the case there. The IO has stated that the investigation has revealed that the accused persons are habitual offenders with multiple criminal cases registered against them against various police restrictions between 2016 and 2025. The list of those cases have been enumerated. The investigation is stated to be in active progress. In the given facts and circumstances, I'm of the considered view that that is not in the interest. It would not be in the interest of the continuing investigation to grant bail to the accused. Accordingly, the interim bail granted to the accused by order dated so and so stands cancelled, and the instant bail petition is hereby rejected. The petitioner shall surrender before the learned learned court below, concerned learned court below, within 7 days, failing which the learned court below will be at liberty to issue an NBWA. The return back the case there. Okay.
Matter, if a lordship goes to the water 11, but how the police has,
That's why, prima facie we cannot.
because it is syndicate, my lord, it is what syndicate is there.
I mean, this kind of, see what is syndicate actually.
But
what
he
is
is
a
not a
syndicate?
member of syndicate, don't, see, before attracting,
What is this dictionary meaning of syndicate? No, it's very difficult. Anyway, let it be. Can approach this higher level on higher level. Anyway, I'm not inclined. It will come mix up. So yeah. Interim bail granted by order dated 1610. Stands rejected. Very bad situation, no other option. Otherwise, anyway, it's okay.
59.
59 is yours. Yours. 59 is yours.
Yes.
59.
CD is received.
CD received, my lord. Here, my lord, in this case, my lord, in this case diary, my lord, detailed, my lord, report regarding the present petitioner along with the number of cases, those cases pending against him, FIRs, my lord, everything is available in this case, my lord. In this case, petitioner was soon arrested. Initially, he was arrested in, my lord, West Bengal. Thereafter, my lord, on the basis of the production warrant, my lord. Thereafter, he was arrested by West Bengal police in a case while he was trying to escape, while a nakaseking was going on there, my lord. Thereafter, my lord, he, my lord, shoot at the police, my lord, who was on duty, my lord, there. And thereafter, against him, there in West Bengal, also one case registered under Arms Act. Thereafter, my lord, he was soon arrested in the present case, my lord.
But those things is not in the affair. That is their version.
Later on.
Later on.
There is a bail rejection order here.
Yes. Earlier, my lord, during he also initially filed anticipatory bail application that was rejected.
So far, my lord, if your lordship goes to the merit of this case, I just read out, my lord. What is the merit?
Just a minute, I'll come to that.
Then I have to argue on this. If he want to argue, I will argue. Or later on, it will.
Let me just refresh.
Something to
Because this is
discuss.
slightly different.
What is the allegation they FIR and what is the actual pay?
This is Lotasil PS.
Yes, Lotus LPS. Initially, my lord, in this case, he was initially arrested, soon arrested. My lord.
Item 59 is Lotasil PS. I'll mix up. Just a minute.
My lord,
I just see the narration and negation. seeing the allegations. So this is also on similar footing.
Yes.
No, no, my lord.
No, the allegations.
Allegations are, my lord, almost.
No, allegation I have some,
And regarding,
some,
I'll
so,
come-
my lord, my lord,
I'll
before.
come to you.
Uh.
Now you tell me. Let us go to the FIR.
Let
Let's
us
read-
go.
let us
That is
read
the thing.
properly.
I want to go to, yes, the previous one also 322 You have not gone through the FIR, my lord. You just go through the FIR, then you said whether, what is my fault? What is the allegation in the FIR? 322, please, your lordship, take up this matter again. You just go through the FIR. I
35.
was silent because you are passing the order, I was silent.
35.
So, yes, 326.
that
Yes.
already in that case.
Yes, they already you cancelled my bail, but you go through the FIR first. Then I am coming on merit. I don't know how they
FIR is at page 11.
14, 326, earlier one, where you have cancelled the bail.
Earlier one. we
13,
already passed the order.
326.
No, on the basis of CD materials, we have cancelled.
Yes, serious, just read out for FIR. What is the FIR? Just read out, then you bail and observation.
Give me 11.
Misleading, just some point is there.
Well, I am
No,
not
no.
misleading anything. What is there?
What
in
is
case
it?
diary?
It's read by
Why
FIR.
can it be said
You have
there is
to
case
read the FIR.
pending?
He
And not
does not
only,
mis-
my lord, in this type of offences, my lord, everything is there in Lotasil PS. My lord,
No,
FIR,
maybe,
who has
maybe,
filed
no.
complaint, my lord.
Because he was
A
cheated.
person-
My client was cheated.
Oh, your client was
Hmm.
cheated, well, that was different.
He
Why
was
you-
cheated
But
in
I am
11
not misleading
situation.
anything. What is there?
Hey, my lord,
in-
11 cases he was cheated.
My lord,
He's
you
a-
just read my lord
he-
FIR.
He's a victim in 11 cases. That's
Page 14, page
You
14,
should
my lord.
also file a case then.
Yes,
11
my lord.
cases.
Page 14, my lord. Page 14 FIR.
Yes, I've seen this.
No, my lord. With due respect, I am to inform you that while the agreement that I purchased a vehicle, he has purchased a vehicle and condition on the said agreement, accused person number was supposed to clear all the pending installment against said vehicle to the finance company. And if she fails to do so, she will liable as per provision of law. That means accused wife, she is the owner of the car, she has sold that car and his amount is 17 lakhs. The accused part number one was supposed to pay the, how first thing is that, how the informant has purchased that hypothetical car. That is one aspect. Yeah, always I am wrong. Why the informant has purchased a hypothetical car? Whether bank is allow him to purchase a
Many materials have emerged.
Yes, but the surprisingly, any mistake of accused person number one, which is instrument has not cleared a pending any installment against the said vehicle. The accused person have not signed any document for transferring the vehicle in my name. Having no other alternative, I have cleared the pending
No,
installment.
that's okay.
Yes, my lord.
That's okay.
And my lord,
So let us not waste the time of the waiting councils,
my lord, you
There's already-
you like to go through
No,
Annex
you go
21.
to Apex Court. He's a rich person, Don't because I'm also a human being. This this is already dictated. We'll waste the time of the other councils. He can go to the Apex Court, and of course, at the subsequent stage, he can again come before this court. No, this is I've seen the FIR. The
No,
allegations
not
it
FIR.
started like that. See,
Page 21, my lord.
you
My
know
next
too well. You
Page
know too
21,
well.
my page 21, my lord.
You know too well that that FIR is not an encyclopedia. Many things emerge.
Yes,
the
yes.
section of organized crime was added later.
Yes.
There are very serious materials which I have seen, and they have given the list of all the same provisions. Same provision.
And initially, at the time of my argument, I in fact pointed out to the court, yes, prima
Let's
facie
come
from
to
the
this.
FIR, it seems like a civil case, but while going through the case.
Please
my lord,
understand, sir.
that's
Let us
everything-
come to this section. This section. Let us come to this petition.
Yes.
Sia's car.
Yes, 3152. Let's go through FIR, my lord.
35 2025.
This is FIR, my lord. Page 17.
Yes.
Respected sir, at first I want to state a series of incidents that took place within us. Regarding the matter, we have brought one CS car having registration number so and so, India year 21. Now we wanted to purchase one new car. And for this, I, along with my father, decided to sell the above mentioned car. And regarding this, we have posted an advertisement to sell the car on different social media platform. On the date 24/5/25, one person introduced himself as Ajit Roy, contacted us and he told us that he is interested to buy the car. Then after the clarification, decision with him, through phone call, I invited us to for discussion at Navy restaurant near Nehru Park. Accordingly, I, along with my father, family member, came to Navy restaurant on dated 27/2 and about 26:30 p.m. and I hand over some documents like PAN card, Aadhaar card, the original form of so and so of my father, Pranab Kumar Das, to him. After that, the person named Ajit Rai told us that we need to transfer vehicle registration number so and so in his name. Accordingly, on dated so and so at about 12 noon, I, along with my father and Ajit Rai, went to the office of DTO Kamrup for closing the same. On the DTO office, where we three of us went to SBI Maligaon and submitted documents for taking a loan to make payment of new car, which we planned to buy after selling the old car. After that, we went to Mahindra dealer and I made payment of rupees 21,000 through UPI at Mahindra dealer for booking the new car. And I dropped Ajit Rai near Ujan Bazar. As per discussion, we have to deliver the new car to Ajit Rai and he would deliver the old car to Ajit Rai and he would pay rupees 10 lakh for the car to us. But he told us that he will make the clear down payment for the new car at Mahindra directly instead of giving us the said 7 lakhs. And he said that he would pay total amount of rupees 10,50,000 as down payment at dealer for the new car. And he asked to hand over 3.5 lakhs to him. Accordingly, I have handed over 3.5 lakhs to him at Ujan Bazar. Now the person, namely Ajit Rai, not picking the phone call and he switched off the phone. And on dated 28/9/5/25 at about 2:27 p.m., he took the old CS car from me, old CS car from me near Guwahati High Court, saying that he will wash the car and he will come to Mahindra dealer, but he could not come as his phone switch off. The person who auditor fraudulently took the CS car from us without making any payment, along with additional 3.5 lakhs, which I hand over to him for making down payment. Therefore, I filed this case for taking necessary action against the culprit. So there nothing about that Arms Act, nothing. And FIR is something. And if you lordship go through my
Transaction of more than 1 crore was found into the account of the wife
Yes.
soon after the incident.
no, my lord.
As per
Now, if you lordship go through my page 29, I've annexed the document where they have signed, notary.
Hmm.
Just go through that later. Between the informant and the accused. Page 29. This deed of agreement made only between Pranab Kumar Das, Sri Jogan Chandra Das, limited hearing called the first party, which term expense independent of meaning exchanging clear and Dharmeshwar Rai, and presently residing in Kahalipara, which whereas the first party is absolute owner of the vehicle. Pranab Kumar is absolute owner of the vehicle, and he agreed to sell the vehicle four-wheeler vehicle manufactured by Maruti Suzuki, model Ciaz, being registered so and so, to see Dharmeshwar Rai, so and so, and presently residing, whereas the first party with pre-content and without coercion and undue influence and misrepresentation and mistake is willing to sell his vehicle to the second party purchaser, and the second party, after exceeding the considered amount, has agreed with the proposal of the first party. Now this I agree witness that the total consideration of vehicle is fixed at 5 lakh. The second party has already paid rupees 5 lakh. Already paid.
Just
Cash.
a minute, I'll come. CD's receipt.
CD receipt, my lord, this is here, my lord, detailed investigation along with the FIR, my lord.
Commission.
Oh, yes, my lord, I will point out, my lord.
So this here story is different.
My lord, initially, earlier at the time of argument, I, my lord, fairly pointed out to this honorable court that yes, from the prima facie, from the contents of the FIR, it seems a civil case. But while after going through the case diary, a number of cases pending against the present accused person, the modus operandi, how, yes, he has some capacity to attract persons, my lord, and for which, my lord, people trusted him. And thereafter, by breaching everything, my lord, initially he not only took over the vehicle, thereafter, my lord, he cheated. He in fact not paid a single amount to all these accused persons. In this manner, he along with his wife, my lord, and thereafter, my lord, huge account of money, all these bank statement available in the CDR. my lord, more than, my lord, crores of rupees, my lord, bank transaction in her account, my lord, through the present accused person, my lord, and without any, my lord, source of income, my lord. And regarding other cases, my lord, your lordship, that is FIRs and everything is there in the CD, my lord. How these accused persons, my lord, involved in, and regarding, my lord, arms act, yes, arms act is not there in this case, because petitioner was initially arrested in a case of West Bengal, my lord. Well, on the basis of secret information, the West Bengal police, my lord, to apprehend the present accused Natasha King was there. At that point of time, he shoot at police, and thereafter police apprehended him because at that point of time, he was
No,
gone on the-
no.
that is everything
It,
is there in the case,
you have
but
seen that empty cartridge from his
I
residence.
don't know about my
Yes,
everything
yes,
is there
yes.
because the case is
No gun is available
one
at
case
his
at West
possession.
Bengal was registered. It
Mention
is
is the
on the
one
check is also there.
that with some Kolita, they were found and they tried to be
Yes,
apprehended, then they ran away.
Yes,
There was
yes.
an incident.
For which, and thereafter, my lord, in this case, my lord, after he was arrested in West Bengal, my lord, he was on the basis
If your
of the
lordship goes to
corruption
scissor list, you will find.
He
my
was
lord.
shown arrest.
shown arrested in this.
And in this case, my lord, he is already
No, what
custodian
is there
74
in the
days.
CD? It is my I pointed out to your lordship, my lord. Otherwise, my lord, granting rejection, everything is up to your lordship.
It is
So,
already in
what are
custody
the
74 days,
materials,
they have not
everything I
filed any
pointed out
charge
to
sheet.
your lordship, my lord.
You know why they have not filed charge sheet? 74 days, already in custody, more than now 74 days.
No, we cannot question whether why if the statutory period is there 90 days. We cannot say why you have not filed on 60.
No, that is a different issue.
That's up to the
But yes, my lord. But statutory period is over.
statutory period is over.
In this case, my lord.
You calculate it is over. Then it's
Otherwise, in this case, my lord, he is in interim protection, my lord, on the same ground of held ground, my lord. Thereafter, in view
He
of
was shown arrest on 10.
now he is in outside jail, my lord.
No. Shown arrest on 10/8 and released on 23/10. Already interim that
interim was granted on 14/10.
14/10 and released on 23/10. Same case earlier.
If you suppose you do not file the bail bond, that's not the
Yes
fault of the system.
Yes.
If after submitting bail bond you don't write the release order, then it's our fault.
Otherwise, my lord, on the ground of violation of this honorable court order, only on that ground, my lord, this bail petition is
No.
because
I've
on
already
the
last
pretext of-
last occasion, my lord.
In this case, statutory bail is over. Statutory period is over.
Statutory
90
period-
days. 11, 11, 11. It's over.
Yes, sir.
It's over. In this case, it is over. So probably he has to be given bail on this.
My lord, because at that point of time, at the time of getting interim protection from this honorable court, at that point of time, my lord, that statutory period was not over. And
Not over.
Not over. And on the on held
So
ground-
that's why I think that period, I have not found any
Yes,
law.
So, my lord,
that
I will- regarding
exists
that
to be
aspect, I will
excluded.
check. Then your lordship may fix tomorrow regarding
Day
that
after tomorrow.
law. Yes, on Wednesday. I will.
In this case, the petitioner was shown arrested on 11/8, was stated to be shown arrested on 11/8/2025. Full stop. And he was granted interim bail on held grounds on 14/10/2025 with a direction to surrender on 7/11, which he did not do so, but he sought an extension of the interim bail and by filing a additional affidavit projecting continued held grounds. Full stop. The learned additional PP 6 some time to ascertain the legal position regarding detention vis-a-vis statutory period, in the context of the petitioner being on interim. Prayer is allowed. List the matter. The interim bill stands extended till the next date of listing. List the matter on Wednesday.
Wednesday, same time.
What about the case diary be retained?
Case diary be retained.
Edited.
Just hold on. Any connected, madam? What is it?
I've had a motion which has not been called. I don't know why. Motion at Asita. 57.
Oh. Yes, it was there. Yes. Sorry.
No, Lordship, I had come against for quashing of the proceedings
Quashing
of,
petition.
Of a DBK, domestic violence case. Lordship, I have to give a little history before Lordship gets down to it. That I got married with the respondent in 2010. and it was solemnized in the customary way as it was registered in Bangalore in 2014.
Mhm.
But what had happened after I got married, that was in 2013, I was diagnosed with a girdle muscular dystrophy. That is a degenerating disease where the muscles lose their potential, strength and thing. And so and that was what thereafter a child was born in 2014 again, which was after this happened, things were fine. They were abroad. They came back. 2018 Lordship respondent started when obviously he was started getting his muscles started getting weaker. Respondent started misbehaving. And finally, Lordship, she filed a divorce case on 13/2/2023.
Mm.
In the meantime, she left the house and stayed in a rented flat with her son
In Bangalore.
in Bangalore itself. Then on 13/12/2023 to 2023, she filed a divorce case on the grounds of cruelty.
In Bangalore.
In Bangalore. Her grounds were like they didn't take me for a honeymoon.
When was it filed? Divorce case.
On 13/2/2023.
13
On grounds of cruelty.
13-2.
13/2.
Okay. Yeah.
Then Lordship, the petitioner, she also filed a petition for guardianship and custody. The guardianship and custody, the court granted visitation rights. And this visitation rights were initiated for Saturday, they were afterwards extended. And she claimed the maintenance of 1.5 lakhs per month. The family court, by a reasoned order, gave her 15,000 rupees per month for her child, which I am paying, Lordship. I'm even providing for my son's education. Then, Lordship, what happened? In spite of the custody order for visitation order, I was not given the visitation right. So I filed a contempt petition. All these things happened in Bangalore. Lordship. And after I filed the contempt petition, she came back to the matrimonial house. And finally, on 25/9/2025, she withdrew her divorce petition. Thereafter, came home. Then what happened? Then again, Lordship, the whole saga of cruelty and misbehavior towards the petitioner's mother started. Then on 26, this date is wrong. On 26/25, I filed a divorce case.
Yes. 26.
26. Lordship, she withdrew her divorce case when? No, in 24, Lordship. September 24. And I filed it on 26/2025.
Yes.
Yeah, I will.
Okay.
Lordship, in this case, Lordship, the FIR is page 11. Lordship. Scan copy of the there was called for Lordship. FIR is
Page
11.
Okay. Yeah.
Mary. I am
Vijit.
Karmakar.
Before my learned subject, my lord, I take to my lord point on the last order passed by the honorable court, my lord.
Yes. Last order.
Last order.
So maintainably.
Because my lord, this is a my lord bail application, my lord, against the order of the NIA court, my lord. So my humble
NIA
my lord, NIA court, my lord. This is the order of the my lord coordinate bench, my lord, whether my lord the point was maintainability point was my lord discussed, my lord. And it was hold that, my lord, in case of my lord, the order passed by the my lord NIA court, my lord, in respect of allowing or dismissing any bail application, my lord. The appeal will lie, my lord, before the divisional bench of this honorable court.
That's true. Section 21. I think,
Section
of the NIA.
21, my lord.
But see, there are two kinds of special courts under the NIA.
No, my lord.
Yes.
As part of my
One
lord,
is the designated NIA court.
no,
right.
there is no designation, but for that, my lord, Lordship may kindly peruse. My lord,
Vikramjit Singh.
my lord,
Judgment.
paragraph, my lord, 8 of this, my lord, order, my lord.
NIA. That's NIA. And National Investigating Agency. Yes, para.
paragraph 8 of the order, my lord.
No, as far as NIA court is concerned, I'm aware of this provision.
Yeah.
Let me just refresh.
Because as part of my lord notification of the government of Assam, my lord,
Mm.
the cases, my lord, which are being tried by the my lord session judge, my lord,
Yes,
there has been designated as an NIA court.
yes,
my lord.
yes. This judgment is still pending. Or it has been held to be not
No, my lord,
intimate.
this, in fact, my lord, regarding the point of limitation, my lord, that is why, my lord, this, my lord, bail application has been, my lord, referred to, my lord, the division benches of this honorable court, my lord, to decide the only, my lord, the limitation point, my lord. Because there is a limitation, my lord, as per section 21, my lord, of the NIA,
Mm.
preferring, my lord, bail application, appeal, my lord, that is appeal, my lord.
Let us see the definition of special court
Yeah.
in the NIA Act. It must be there, right? It's not there, definition. High court, special court. Special court means the court of, means special court of citizens, special court under section 11, or as the, yes, this is clear. The law is exact, in my opinion, what I understand. You want to submit something?
Sure.
No, the thing is, subject to correction, I think this is the law. The NIA, this schedule offenses
My lord.
can be investigated by NIA or by state police also.
State police.
If it is investigated by NIA, it has to be before the designated NIA court, which is
My lord.
our Chanmari.
Yeah.
Chanmari. And if it is investigated by state police,
My lord.
then it has to be before earlier it was before the magistrate and everything
My lord.
also, but it has to be before a special court.
If the, my lord, offense is connected with the, my lord, UAP Act or, my lord,
No, those schedule of
Yes, schedule
of
offense.
NIA,
That's
where even currency is there, fake currency and all these offenses also. So in the Vikramjit Singh judgment, the Honorable Supreme Court said that all offenses of NIA Act has to be by the special court.
special court.
So if the state government will be at liberty to set up special court,
special.
special court for investigated by for NIA schedule offenses investigated by police.
Police.
If not, then the jurisdictional sessions court will be the deemed special court.
Deemed special.
Deemed. So till now, our the sessions courts were the deemed special courts,
Yes,
right? But now government has come up with a notification that the courts are under 22, right? Let us clear this.
Yes.
Yes.
Yes, you can give me. Yes.
Notification.
Notification, yes. Section 22, now it is not deemed special court. Now it is special, designated special.
Designated.
Now the question is, we know this, I'm aware of this, that first there is no concurrent jurisdiction with regard to bail for NIA schedule offenses. You have to file there, then come in appeal, that too heard by a division bench, right? So that is section 21. But my question is whether the said restriction would apply to an order passed by a sessions court as a special court with regard to a state police investigate NIA offense. It seems the answer is yes.
Yes, my lord.
Because this also I had forgotten, but I'm learning now.
For this, my lord, you may peruse the paragraph 22 of the order.
Yes.
Paragraph 22.
Yes. Fine. And this is clear actually. You kindly see, do you have the NIA Act?
I'm not taking on.
Section 21,
Yes.
right?
Yes.
Shall lie from any order, sentence, or judgment of a special court to the High Court. Court on facts and law.
Yes.
But what is special court? I'll give it to you, this one. So we do have a problem of maintainability. Special court is defined in section. Do you have the act? No. It's not very common act actually. Initially, there was a lot of confusion in the districts because people are not familiar with the schedule of NIA. I had never seen the NIA Act before I walked there. Because people were confused what to do, which offenses will. Anyway, Section 2H, Section 21H, special court means a court of session designated as special court under 11 or 22. Other 11 or 22. Just see this. This will clear us. 22 is state government, 11 is central government. Central government means NIA investigates, 22 means state police investigates. That's the position. Which provisions of NIA this
Nothing is there, Lordship. In here, what happened, Lordship?
Then
is
why this?
Only section is 143B of BNS, trafficking of person. Trafficking of person. This is, and it is, Lordship, investigated by the state police, charge sheet submitted. After that, Lordship, court passed this order, Lordship. May I?
Because I know the background, there were tremendous confusion with regard to this. Obviously, because people are not familiar with this. Now the sections are different. One traffic. This is corresponding to 370 earlier. 370 IPC 370 earlier.
After the charge sheet, Lordship, this order has been passed on. And this special NIA case, this nomenclature has been only for trial, Lord.
So I cannot touch the issue of maintainability, right?
Yes.
That is to be, my lord.
I know it's not maintainable. You have to go to Session Judge Kasar and whatever order he passed, against that you come here. Because with regard to this, well, you are saying that 143 is investigated by state police.
State police.
And therefore it will not be right.
Okay.
This is a very, it's okay, absolutely, it's absolutely, fair to have that kind of confusion. But let us see. Because this NIA schedule also has to be amended now because it was referring to IPC sections. One 143 is the equivalent of 370. NIA Kondibor. You can tell me from there. You have the NIA, Mr.
Yes, madam.
Please, no, I don't want it. You can guide me.
Yes, madam.
Kindly see the schedule of that. Does it include trafficking? I think it does. Because there was a huge Rohingya trafficking case in there, which was brilliantly investigated by NIA in that case. One of the best investigations I have encountered in my career. Innocent girls were, and they were rescued. 370. Schedule? You found the schedule? Should be at the end, and should be at the end. This hijacking, atomic energy cases, very serious offenses actually. But currency is included and trafficking is included. Otherwise, it is all this Arms Act, UAPA. Except interlocutory orders, it says. That means bail is not an interlocutory order, the purpose of NIA Act.
My lord, schedule mentioned, my lord, the explosive substance, my lord, then Atomic Energy Act, Unlawful Activities Prevention Act, my lord, Anti-Hijacking Act, Suppression of Unlawful Act against the Safety of Civil Aviation, SAARC Convention to Suppression of Terrorism Act, the Suppression of Unlawful Act against the Safety of Maritime Navigation and Fixed Platforms on Continental Shelf Act, the weapons of mass destruction of their delivery system. My lord, these are the and the my lord, offences under chapter 6 of the Indian Penal Code, my lord.
This is where it comes. They have to amend the schedule now. Isn't it? They have to amend the schedule. Chapter 6. Offenses against state and then yes, these are war and this all these things, waging war and these things. 121, 121A.
121 to 130. my lord.
And next, what is the next
And
category?
section 370 and 370A of chapter
Yeah.
chapter,
Trafficking.
16, my lord.
And 480, 489
And
C,
489, my lord,
fake
this
currency,
fake
counterfeit
currency,
currency.
my lord.
Because these have element, this can
Then
have
arms
elements
check,
of
my-
terrorism. That is why this
Right.
has been.
Yes.
International fake currency transaction can have element of terrorism. That is why probably it has been. Chapter 16.
16.
You're not remediless, it's just a question of course. Chapter 16 is
Offense affecting the human body, my lord.
it falls human traffic. So see, the thing is that Mr. Prosecutor,
My lord.
what I feel is that since a coordinate bench is already seized of the matter, it will not be proper for me to jump and say anything. So I'm clear in my mind actually. So you think about it. We can adjourn it today. You think over it and discuss.
Yes.
Then you can withdraw this matter and file it in sessions with liberty to file in sessions.
Dr. P,
This is the position.
already I have filed it against the sessions case order.
That will not be what? Already rejected once.
Already rejected. Page 24.
Then you can file it as an appeal perhaps. Because you cannot, it's a matter of liberty. You cannot wait for the outcome of the
My lord, that
maintainability
trafficking
issue.
of person, my lord, 143, my lord.
Hmm.
Ifs come under, my lord, chapter 16, my lord.
Hmm.
That
Yes.
is, my lord, 370 of the IPC.
Traffic. They have to amend the schedule now.
Yeah.
So if you file before sessions court, it will be like a subsequent bit. But if you file it before division bench, what is the final conclusion in this order of
So
coordinate bench?
regarding the, my lord, it was held by the appeal will lie, my lord, for the division bench. And but as part of the limitation point is concerned, my lord, for that purpose, my lord, it has been referred to a division bench.
So we can, okay, this lying before division bench is clear.
Yes, ma'am.
We can direct him.
Yes,
Yes.
sir. Yes. To file an appeal, my lord.
File an appeal.
File an appeal.
It will be before the division bench. Which limitation issue?
My lord, regarding my lord, 41 to 21, my lord, 4. What's the can you see? My lord, 21, 21, 5, my lord. Every appeal under the section shall be preferred within a period of 30 days from the date of the judgment, sentence or order appeal.
30 days.
30 days.
And what is the portion of limitation? Whether section 5 will apply?
Section 5 will apply, my lord.
Is there anything in the NI Act regarding condonation of delay?
In this case, my lord, this order was rejecting his bail passed on 37, 2020.
Long time.
So when 30 days will already over.
The petitioner must approach this court immediately.
Hmm?
After rejecting the petition before the session court lordship, petitioner filed this petition on 13 October 2025 immediately within 30 days.
Not
It was rejected on?
So,
rejected on 37, my lord.
political chairman limitation of bail filing
37 and you filed
37, 2020.
and you filed the
13 October
no, it was rejected there on 37.
37.
Then you filed this petition on
13 October.
it was beyond the
Beyond that.
Is there anything in the I forgotten? Is there anything in the NI Act regarding condonation of it? Nothing.
No, my lord, that for that purpose, my lord, section 21, 21, 5 will
Nothing.
apply, my lord.
Nothing, right? No proviso, nothing. So maybe 29 of Limitation Act can apply.
Yes,
we
sir.
can,
Says, my lord, he has filed
five
bail
can apply.
application, my lord.
Mm.
So he can take a plea, my lord.
It's
Then,
liberty
my lord, since
matter.
I have filed this bail application, my lord, without knowing the, my lord, the provision of
Yeah.
section 21(4), my lord.
Section 14, that is okay.
Yes.
But even otherwise, it's a liberty matter. There cannot be,
My lord.
limitation. There cannot be, there cannot be a case of no remedy for delay only. The petitioner heard, so and so an additional PP RJ Borwa. The petitioner is invoking section 483 BNSS seeking bail with regard to special NI case number 26 of 25 arising out of Kalan PS case number 15 of 2025 under section 143 subsection 5 BNS. Full stop. The case is stated to have been charge sheeted already and pending before the special judge Kasar as the aforementioned special NIA case. The petitioner was arrested on 27/4/2025 itself. The learned additional PP has drawn my attention to the order dated 28/11/2025 passed by this court regarding maintainability of this petition before this bench. Placing it is order dated 5/12/2025 passed by coordinate bench in bail application 1727 of 2025 has been placed in which the coordinate bench, the learned coordinate bench has held that such bail applications would be only by way of appeal and would be maintainable before the division bench in terms of section 21 of the NIA Act. However, as per section 21(5) of the NIA Act, such an appeal has to be filed within 30 days. And on the question of limitation, the matter has been directed to be placed before the division bench. In the instant case, the petitioner fairly submits that preferred a bail application before the learned special judge, which came to be rejected on 30/7/2025. And thereafter he filed the instant bail application on 13/10/2025. Also. In terms of the judgment of the Honorable Apex Court in Vikramjit Singh versus State of Punjab, all offences appearing in the schedule of the NIA Act have to be investigated, have to be tried by the special court under section 11 or section 22 of the Act. Stop. Section 11 pertains to special courts set up to try cases investigated by the National Investigating Agency within bracket NIA, and section 22 pertains to cases investigated by the state police pertaining to offences of the NIA schedule. It was held in the judgment in Vikramjit Singh Supra that till special courts are set up by the state government, the jurisdictional sessions court will be the deemed special court for this purpose. However, in the meantime, by notification dated 31/5/2022, the government of Assam has designated the courts of sessions judges as special courts under section 22 of the NIA Act for investigation of cases investigated by the state agency. Section 21, what is that subsection? 21(2). 21(2).
21,
Where appeal lies.
So 22, my lord.
Section Section 21, subsection 2.
My lord.
Subsection 2 of the NI Act provides that any person aggrieved by judgment or order of the special court, except interlocutory orders, shall prefer an appeal to the High Court to be heard by a division bench. The special court is defined in section 21H as follows. It does clearly deems jurisdictional sessions court now designated as special court by the state government notification will fall within the ambit of special court under section 2120. Thus, in terms of the decision of the coordinate bench, also in terms of section 21 subsection 2 read with section 221H of the NI Act dash concurrent jurisdiction under 483 BNSS cannot be exercised by this court along with the special court, and that initially the aggrieved petitioner shall have to move the special court, and if the bail and any party aggrieved by the order on such bail has to prefer appeal to this court under section 2120, and such appeal is to be heard by the division bench. Under section 21(5), any such appeal has to be filed within 30 days. There is no specific provision in the NI Act regarding condonation of delay in case such appeal is sought to be filed beyond 30 days. The learned coordinate bench has placed that issue before the division bench for pronouncing the law on the point. The given facts and circumstances, the instant bail petition is dismissed as non-maintainable. However, the petitioner is at liberty to prefer the bail, prefer an appeal before the prefer an appeal under section 21 of the NI Act, and in any such appeal he would be also at liberty to seek condonation of delay. He also contain the issue of limitation. Contain the issue of limitation. The bail petition stands disposed of on the aforesaid term. That's okay. Good. Quickly. Or if you want to file subsequent grounds, or there more things have come up, then you can prefer it before. It's not UAPA where 43D2 is applicable. That prima facie materials, no bail can be granted. This is trafficking. So the special judge, those statutory restrictions are not there. So if investigation is completed or everything, then you can also take that route also. But again, it will take some time. Then you come again, or you can on these materials also you can come with the appeal. It's up to you.
Please, Your Lordship. My Lordship. Here in this case, Your Lordship, charge sheet already laid, Your Lordship. PCR called, Your Lordship. On 86 date, charge sheet was called where on which day about to grant bail, Your Lordship. So my submission is restricted to Your Lordship. Page 21, Your Lordship, you pay this forwarding report, Your Lordship. Makes it clear. Because on the date of incident, Your Lordship, the husband of the informant, he went out with the deceased, Your Lordship, along with two other friends, Your Lordship. So they attended one at the house of one of his colleague, Your Lordship. So that person also died, Your Lordship. So that day, Your Lordship, the informant's husband, he was totally under the influence of intoxication, Your Lordship, in a very bad condition, Your Lordship. So subsequently, all the three friends, Your Lordship, they bring the informant's husband, that is to the house of the informant, Your Lordship. And seeing her condition is very bad, that day he was uh, stayed in the night, and next day, seeing the condition is aggravated, Your Lordship. So they are shifted to the hospital. And the next day, that person is died. And suspicion draws, Your Lordship, that since the person, informant's husband, died, uh, uh, since the husband was accompanied with us, Your Lordship. So some suspicion has been drawn that this allegation brought in the affair, that this person, they're the main perpetrator who killed the, because otherwise FIR is haphazard, Your Lordship. FIR, if you Lordship look into page 17, the Assamese vernacular, Your Lordship. For FIR is, there is no prima facie, I think, nothing comes out, Your Lordship, after recital of the FIR, Your Lordship. So my submission is, Your Lordship, since charge sheet is filed already, TCR been called, Your Lordship.
Trial is going on.
Trial is already commenced, Your Lordship. But I didn't receive the summon as yet, as per information derived, Your Lordship.
No. The evidence is not started.
No, start, not
Only,
start.
You are being summoned.
only, my lord, the matter has been committed to the session court.
Session.
So, Your Lordship, prerogative.
Since 4/9.
Yes, 90 days, more than 90 days, I'm beyond the bar.
If there is no apprehension
Yeah.
to the, if there is no special apprehension to the victim, or it can be enough.
That part I will leave it to Lord, my lord. Already, my lord, I have gone through the scan copy of the record, my lord, and I have flagged them, my lord, relevant portion of the statement, my lord. They are directly not implicated, my lord. That is, these are the, but he was, my lord, the victim was with him, my lord. And
He was on?
witnesses said, my lord, the victim along with the accused person, my lord, they went to a, my lord, my lord, native village, my lord, for the purpose of cremation of their friend, my lord.
Yes.
Then in the friend's relative house, my lord, the victim, he consumed liquor, my lord. After that, while returning back, my lord, he became unconscious, my lord. And the next day morning, my lord, he was taken to hospital, my lord, where he was he died, my lord. The witnesses, lordship, have perused, my lord, they are directly not implicated.
Yes, Lordship. And FIR also speaks the same, Your Lordship.
That's okay. Be fair to give bail. They'll face trial.
Lordship.
Charges framed.
Lordship.
Third day Diwan, RJ Porwal on a petition. Invoking 483 BNS, the three petitioners seeking bail in connection with Mongoldoy PS case 174 of today. They were arrested on 4/9/2025. In this case, the Azahar was lost by the wife of the deceased on 3/9/2025. It is stated in the Azahar that on 30th August 25, her husband went to his native village on their four-wheeler vehicle along with the petitioners.
Forwarding is more clear, Your Lordship. Page 20.
Subsequently, it appears to be one thing. Is the translated copy complete?
Lordship.
Seems to be one.
Yes, page दिया होना चाहिए.
Anyway, use the forward.
11. Lordship, sorry, one page is missing. I think
That's
that.
It
One
looked
pa-
incomplete. Well awkward.
One page.
Subsequently, though her husband came back at night. Bhadra Soikia is the deceased.
Yes, your lordship.
No, no.
No, lordship.
Petitioner, my lord.
Manav Sharma, your lordship. Manav Sharma. Bhajendra, actually,
Subsequently, he
Ah.
expired. And it's not wrong facts. Don't be written. Anyway, since we
they
are not
went to
going much
cremate,
into marriage.
actually, they went to cremate the Bhajendra, late Bhajendra Narayan Sharma at his native village.
Learned Council submits that his limited contention at this stage is that investigation is completed and that they shall cooperate with the trial. The scan record has been received. The learned additional PP, Mr. Borra. Can I record that? Fairly submits that. Can I?
No, my lord, regarding no direct death may not be recorded, my lord. So, like, my lord, it may
no
hamper the trial.
Submits that on the investigation, it appears that the petitioners, along with deceased, had gone to another village to cremate one of their common friends, and thereafter they consume liquor, and subsequently
Not everybody, my lord. This is what this is my lord.
the deceased consume liquor.
Deceased only, yes.
Thank you. This is consume liquor, and subsequently the death of the deceased took place. Much only. The investigation
Statement
is
for my lord with this petitioner, my lord. The
Yes.
victim.
very long narration, so we take it back. It's very short. Take it. Considering the fact that investigation is completed and the case is poised for commencement of trial, and also keeping in mind the length of under trial detention till now, within bracket, since 4925 dash, I deem it proper to grant bail to the accused persons at this stage. So, no other circumstances or circumstances have been noticed by me to
That is only maybe mentioned, my lord. The accused petitioner, my lord, they were all along with the victim.
no,
That
like
may be
it. I'm not getting the expression. Wanted to say something else. Accordingly, the petitioners are allowed to go on bail 30,000
Lordship,
with one
lordship.
surety of the like amount each. Says number one, they shall be available during the trial, not hamper or temporary evidence. They shall not in any manner harass or harm the informant and her family members. The petition stands allowed in this court.
बरोबर
Give oblige, your lordship.
Slow.
May I lordship?
16.
16.
You go past.
Lord, initially, CD was confirmed, my lord. Last occasion, charge was filed, my lord, this information was received by PP. My lord, and thereafter TCR was confirmed, my lord, already received, my lord. Here section, my lord, 118(2), my lord, of PNS, my lord.
What is that?
Lord, grievous voluntarily causing hurt or grievous hurt by dangerous weapons.
That is for 326.
Yes, my lord, yes. Extend to 10 years, my lord.
No, then it's different. And that is life to life. 326 is up to life. Earlier it was like.
Today is 50 days, my lord, behind the FIR is at 8, my lord.
action has become a bit complicated. Oh. If there is grave provocation,
Yes, my lord. The informant's brother, along with 4 person, was coming, my lord. Thereafter, debate was between accused and the informant's brother.
Anyway. right now, what do you say?
Yes, my lord. My lord, I have gone through the second copy of the record, my lord. Charges submitted under section 118(2) of BNSS, my lord. And on 1/12/2025, my lord, cognizance taken, my lord, fixing 12/12 for production of the accused person, my lord. And my lord, as per the materials, my lord, the victim and other witnesses is implicated, my lord. That he has assaulted, my lord. And the medical report is grievous injury caused by, my lord, grievous injury, my lord, only mentioned, my lord. And the vital part of the body, my lord, head and right arm. This is as per the, my lord,
So what
medical
should we
report.
do?
This honorable court kindly may allow, my lord. He will face the trial, my lord, under any terms and condition, my lord. He is a auto driver by profession, my lord. He is a school going children, my lord. He will face the trial. my lord.
Invoking 483, petitioner is seeking bail under in connection with CS Sangsari PS 210/25, which after completion of investigation has been charged and the court is has also taken cognizance. The penal provision is involved is 118 of within bracket 2 PNS. The allegation in a gist is about causing previous hurt with sharp weapon. Full stop. Accused is in custody since 21/10/2020. The additional PT submits that investigation has implicated the accused persons and the injury report also indicates grievous injuries. What is this? No, the incident is like near IIT. Suddenly,
Yes,
they
I
all stepped from the.
This person was.
There's
he was-
something more to it.
Yeah, inside the auto, my lord, this person, my lord, they questioned him, my lord. Then, my lord, this altercation happened, my lord, which later on, my lord, he attacked with a tukti, my lord.
Unknown person, my lord.
The weapon we use, my lord, that is, my lord,
Yeah, that is
the sharp weapon. But, my lord, in the report, my lord, it is not.
There is a
mentioned, my lord.
group, my lord. Person.
Considering the what is it?
But vital part of the body, my lord, that may be mentioned.
Injury, the medical report indicates injuries, previous injuries on vital part of the body. Serious matter. Considering the completion of investigation, the case being poised for commencement of trial, 50,000 with one security, subject to the conditions that number one, be available for trial of hamper or temporary evidence, shall not try to influence or intimidate any witnesses or the informant or his family. Violation will entail cancellation of the
Publishment. CGM Kamrup Amin.
concerned learning.
May please also. Lordship, petitioner is a lordship, high school teacher lordship, he is a BSc teacher lordship, and he is behind the bar last 26 days. The affair at page 9 lordship. Lordship, regarding a
case?
Page 9 lordship.
Yes.
Respectful submission is that today on 9/11/2025, while my nephew so and so were plowing on a plot of land measuring 1 bighah 2 kathas 6 lesa, owned and possessed by me, the below named accused person with pre-planned manner armed with sticks, bamboo poles, hope dao, and other sharp weapons suddenly surrounded the persons plowing on the land from all sides and with intent to kill assaulted my nephew with a stick and sharp weapons, causing serious injuries. And when the two remaining persons advanced to save him, then the accused person also assaulted them with the caused grievous injuries. The injured are at present treating at Agawani CSC. The accused person also took away one mobile phone and detained the ballots. So this is the allegation. So by contention that lordship, he being a teacher lordship, he is not involved at all in this case and he was not present at the scene at all.
All have been arrested, all the person.
Lordship, I
All
have not
FIR
concern, not, perhaps he will.
Not, you don't have, you may not have information.
Yes, but lordship, he being a high school teacher, BHC teacher lordship, and he's behind the last 26 days lordship. And considering the length of detention lordship and as well as lordship impact on the society lordship, he's a school teacher, BHC teacher.
Mojnu Haq.
Yes.
That's number 3.
Yes.
That is come.
Yes, case they received, my lord. Case they received, my lord. Here in the case
You
there
only
is.
submit, we are running short of time.
Yes, my lord. Case there
To
are
go fast.
two injury reports available, my lord. One is, my lord, simple injury and other is grievous. And regarding involvement of the present petitioner, my lord,
And the
statement
injury grievous by?
grievous by blunt weapon, my lord.
Yes, lordship, that is bailable lordship.
And my lord, regarding blunt object and regarding my lord, involvement of the present petitioner, statement of the 3 injured witnesses available, my lord. Injured stated that my lord, FIR or Nam Thoka Podokia Gone. Though my lord specifically Mojnu Haq name is, but my lord FIR or Nam Thoka Podokia Gone. That is the statement of all the 3 injured witnesses. Other witnesses, my lord, otherwise specifically name the present petitioner.
Present, they named
Name the present petitioner. And regarding injured witnesses, they have stated that my lord, Ezaharat Nam Thoka Podokia Gone.
Let the investigation continue for some time.
Yes.
In that case.
Lordship, kindly see, lordship, one thing, kindly see, lordship, the
Which are-
injury, this is a bailable offense, lordship. 326 will not come, lordship. 325,
Grievous weapon with blunt weapon.
blunt.
Yes, by blunt.
That's bailable offense.
Yeah, fine.
Yes, lordship. Lordship is a school teacher, 26 days, lordship.
What kind of injury? Where, which part?
Yes, my lord. Laceration on the frontal region, my lord. Frontal region.
Head. Laceration.
Yes, laceration.
No, but head is head.
Swelling on the
Wrong message to society is the other way around, actually. You know, if he's found to be, then if there are materials against him, that will send long message to society. Bail is a different matter.
Yes.
No, but that is that I'm not saying with regard to bail. The way around, submission.
Lordship, kindly see, lordship, one thing.
Anyway, so. Is it Ahmed? He brought up. Invoking 483 BNSS. Petitioner seeking, who was arrested on 12/11/25 is seeking bail in connection with Agumoni PS case number 152. So, as many as 10 persons are named in the FIR, including the present petitioner. The FIR is dated 19/11/25, lodged by Nazrul Haq, with the allegation that on I think it's 1911 or 9/11.
No, so 9/11.
Yeah,
I was wrong.
Azhar is 9/11.
9/11.
That on the same day, when his three nephews were plowing a plot of land, the FIR named accused persons attacked them with weapons, including sticks, bamboos, and sharp weapons, with intent to kill and caused assault. The additional the learned additional PP submits on the basis of the case diary that the eyewitnesses have stated about the involvement of all the FIR named accused persons, while some other witnesses have specifically implicated the present petitioner. The medical report reveals is stated to have revealed simple injury in one case and previous injury caused by blunt weapon in another, within bracket, lacerations on frontal region, within bracket close. In this context, the petitioner counsel summarizes that the said provisions even if the said facts could make out a bailable offense. I find some force in the said contention of the petitioner counsel. Some progress in investigation is there.
Yes, my lord.
The investigation is has also reasonably progressed. In the given facts and circumstances, allowed to go on bail of 30,000 once everything. If conditions operate remaining investigation.
Okay, it was a
The school
CGM.
teacher, one should not be in these things. What message it will send to
CGM,
society?
Lordship Bhuburi.
Concerned on it.
Yeah, obviously.
It's an allegation, but still.
Yeah.
May I please, Your Lordship?
Yes.
My lord, the allegation under section 310 subsection 4, that is the preparation of Dokati, Lordship. My lord,
Preparation for dacoity.
Lordship, I am behind the bar for 25 days. FIR, Lordship, is at page 8. May I read, Lord?
Page 8.
Page 8, yes.
I'll go through it quickly.
Okay.
He's Jairul Islam. Huh?
My lord, I am Zahirul Islam. My lord, so far the allegation is concerned, Lordship, only apprehension is there. There was no commission. And secondly, Lordship, the materials, what they have recovered, your Lordship has already seen that one T-shirt having written in the backside of the T-shirt is police, Assam police. One jacket, one walkie-talkie, Lordship, one mobile phone. These are the materials, Lordship, the police has recovered. My lord, I have annexed the photocopy of the T-shirt, that is, Lordship, page 25. Whether this is, Lordship, this cloth, Lordship, T-shirt is the uniform of the police, your Lordship will see. This type of, Lordship, T-shirt is found available.
There is, but I cannot write, no, Indian Army, police. I cannot write my T-shirt, no? even as a anyway.
Yes, my lord, case diary received, my lord. My lord, initially on the basis of source information, police received an information that these persons are, my lord, planning to commit highway dacoity. And in this regard, my lord, they purchased some Assam police uniforms and walkie-talkie also, my lord. And seizure list is also available, my lord. Police recovered those police uniforms and walkie-talkie also. And that walkie-talkie, my lord, cannot be used by persons like the accused, these accused persons, my lord. Your lordship may kindly.
He was arrested on 14/11.
Arrested on, actually, Lordship, arrested on 13, forwarded on 14. Lordship.
Seizure list also, my lord, available.
My lord, my specific instruction is that only one T-shirt was recovered and these items were added. Why, Lordship, added, Lordship, I have stated in my paragraph 7 in the petition, Lordship.
Nobody can print also this kind of T-shirts.
And regarding, my lord, recovery of the two
There's a
walkie-
penal provision in IPC, right?
Yes.
That it can be, it is an offense actually.
Yes.
Where
Yes.
what is the what is the language?
And not only police uniform, but those walkie-talkies, my lord. So,
Which portion should I see? Marked.
As per allegation.
Your lordship may kindly peruse that seizure list and, my lord, GD entry. I have flag mark. There are 3 flag marks, my lord. And regarding that, my lord, note of the IO first page. Your lordship may below, my lord, regarding those about those walkie-talkies, my lord. When those, who can use those walkie-talkies, my lord? That is regarding that also IO in detail, my lord.
My instruction is this walkie-talkie was not belonging to the petitioner. And that item is added. And this, Lordship, the sofa, T-shirt, jacket, mobile phone, these are, Lordship, recovered from his own residence, not from any other place.
From his own residence.
Yes.
Walkie-talkie, as is rightly said, it needs some permission, I think.
Yes.
Because you can intercept communications.
Not only my lord, walkie-talkie, my lord, police uniforms and everything, my lord, by wearing those police uniforms, definitely, my lord, they are planning to commit.
There is no recovery of any arms and dangerous instrument, lordship. Absolutely a false case. That was, lordship, at the instance of one, lordship, lady who had, lordship, the business relation with the petitioner. I have stated in my paragraph, lordship. 7, lordship. Paragraph 7 in my petition, lordship. "25 days behind the bar, lordship, mandatory 60 days.
Third, invoking section 483 BNSS, the petitioner Johorul Islam is seeking bail in connection with Bongaigaon PS case 290 of 25. Question so and so. He was arrested on 4th. He stated to have been arrested on 13/11/2025 and first remanded on 14/11. The FIR was lodged by a police official from Bongaigaon PS on 13/11/25 with the allegation that a reliable source information was received about the present petitioner Johorul Islam and others making preparations for highway dacoity. Subsequently, highway dacoity disguising as policemen. Subsequently, search was conducted in his residence and in the presence of witnesses, a mobile phone, walkie-talkie of Baofeng Company, jacket, olive color green jacket, and 3 khaki t-shirts having Assam police written on it were recovered from his, were stated to be recovered from his place. The case diary has been received. The IO has submitted an elaborate bail objection stating that the search was conducted based on reliable source information about preparation for dacoity, and the Batfeng walkie-talkie which was found is used by organized criminal gangs because they enable encrypted, direct, and untraceable communications independent of other mobile networks. So, the I perused the concerned GB entry, the seizure list, and the grounds of arrest given to the petitioner. The seizure list tally with the contention of prosecution regarding the seizure of the aforesaid items. Full stop. Investigation is continuing. At this stage, the bail petition stands reject. Return the case then.
Action is item number 1.
Lordship. Out of same affair, Lordship, with item number 19, Lordship.
Same. Have you got a copy?
No,
Well,
till now,
persons.
we have not.
Any materials in the case diary with regard to them? Otherwise, it is
Because my lord, file and case diary both is not available with me, my lord. No,
tomorrow. Fix it tomorrow.
tomorrow, yes.
Let it be tomorrow.
TDS.
Give him a copy. The learned additional PP may be furnished with a copy. The case diary, which was received in connection with a
My lord,
connected
my lord,
matter, may be retained.
my lord, he stated that item number 19, my lord, same CD, my lord, represented. Now you're looking.
Yeah. This was the same CD, the previous one.
Yes, yes.
CD is same.
CD is same.
You don't-
Regarding the involvement of the present.
That has to be seen.
Yes.
Tomorrow,
Tomorrow, yes.
CD be retained. This tomorrow. Must it supplement list. After submission. This one?
Yes, Lordship.
Same, my lord.
Out of 7.
Same method. Tomorrow we'll take. Every person is different, so you see their roles.
Yes.
Click the names and see properly.
20.
May I please your lordship?
Yes.
My lord, 483 application, my lord. FIR at page 11, my lord. In this case, my lord, the charge sheet has been submitted and the charge has been framed, my lord. The case is in evidence stage, my lord. The witness PW1, my lord, has been examined. The informant has been examined. The allegation is that, my lord, the deceased was found dead at night, my lord, is in his own bed, my lord. And in this case, his own wife, son, son's friend, and the deceased friend. These 4 persons were arrested, my lord.
Oh.
Let kindly see at page 21, my lord. Page 21. This Nekibal is the present petitioner before your lordship. He has been arrested. He is the friend of deceased son, my lord. And another person, the Semima Aktara, she is the wife of the deceased. And page 22, my lord, Ramzan Hussain, he is the son of the deceased.
Another son of the deceased.
My
Yes,
son
Mr.
of the
Bor-
deceased.
Bor-
And 23
Mr. Bor-
is the Mirazul Azad, he is the friend of his
Got it.
deceased son. my lord.
Scan report.
My lord, in this case, my lord, scan copy was called for, my lord, but others, my lord, scan copy has not received, my lord.
Has not been received.
Not received, my lord.
Should we wait?
For that may be fixed, my lord, otherwise.
My lord,
we
so
fix an idea, my lord.
far my instruction is concerned, my lord, I have got the instruction that the record has been received by the registry, my lord, but it is received on Saturday. Therefore, it is not on the record. my lord.
Let it come day after tomorrow, my lord, Wednesday.
On 11?
11.
The scan copy not yet available along with the case record, but learned petitioner counsel submits that as per his instruction, it has arrived at the registry. Let the scan record be put up. This is the matter on Wednesday. Or Thursday?
11 on 11.
Any day, my lord, any day, my lord.
11, 12.
Obliged.
21.
May I please? Lordship, some miscreants, Lordship, stolen the iron items along with vehicle of the informant, Lord. And allegations against the present petitioners is that, Lordship, they had assisted the prime accused by providing SIM
Providing
card.
SIM card.
And relevant portion of the also my involvement, page 13 in forwarding report may be seen. Last paragraph. Page 13 and except 2. Last paragraph. Mr. Lord.
Page 13, last paragraph.
Last.
Noor Alam and Mokibul Islam.
Yes, Here in this it is clearly mentioned that, Lordship, the arrested both persons are held the main accused person for the said crime. And Lordship, during the investigation, Lordship, articles already been recovered, vehicle also been recovered, Lordship. And
They were arrested on which date?
26/10/25, Lordship. Last 43 days behind the bar, Lordship. Mandatory period is 60 days, Lordship. Here in this case.
And the Lordship may kindly come to my FIR, my lord. FIR, my lord, annex with the finishing, my lord.
FIR, page 11.
Yes, my lord. Now, Lordship may come to my lord, the third no, my lord, fourth paragraph, my lord. Upon further verification, we discovered that the truck was being used with a duplicate force number plate, number so and so. The contact number provided by the driver were so and so and so and so. The RC and PAN card submitted to us were in the name of Abdul Malik. When we contacted the actual owner, Mr. Abdul Malik, he confirmed that the vehicle number is 6260 belonging to him, but it is a Tata model, not a ISR truck, which clearly indicates fraudulent activity. My lord, the driver, my lord, driver and handyman, my lord, they hijacked the car, truck, my lord, They were actually, my lord, iron rod were loaded, my lord, and it was transported to Pasigat along with some other article, my lord. Then, my lord, they have, my lord, hijacked the truck, my lord, and they sold the entire goods, my lord, to some other person, my lord. Now, my lord, these two persons, my lord,
This,
they have,
he's a, present petitioner is a driver.
no, present petitioner, my lord, one of the petitioner, he has provided his mobile chip, my lord. And other person, my lord, he, my lord, conspired with the other accused person, my lord, and that he helped him, my lord. Now, the question is, my objection is that, my lord, the entire article has not yet been recovered, my lord.
Lordship, we have
So, for
annexed,
this purpose, my lord, at this stage, I am objecting, my lord.
Lordship, we have
Because
annexed,
there needs some further investigation, my lord. The main question is that, my lord, the articles are, it is, my lord, worth rupees, my lord, around several lakhs of rupees.
Lordship, we have annexed, annexers 4 may be seen, Lordship. Articles almost recovered, Lordship, and it is handed over to the informant. Car vehicle was also recovered and it is handed over to that is annexer 5, 4 and 5. And so far my involvement is concerned, Lordship, for 3 days I am behind the bar, we are behind the bar, and mandatory period is 60 days. So further custody may not be required, Lordship. My length of detention may be considered, and considering my involvement, Lordship.
Their involvement is fully in the case diary, my lord.
Can I have?
Yes.
It would hurt so and so. Invoking 483. Petitioners, the two petitioners here are seeking regular bail in connection with Borlomuk case number 154 of 25. And the so and so. They were arrested on 26/10/2025. The case arose out of an Zahar dated. What was the date of the FIR?
FIR is 25.
25/10. What is the
25,
date?
10, 26/10, Lord.
26/10/2025. The allegation that on 18th and 19th October, truck was loaded with iron, steel, iron and steel, and some Kurama, and were supposed to go to Pasigat. Semicolon that on 28th October, where driver had reached Tejpur and was in communication, but from the next day, his phone was found to be switched off. Later, the truck was found to be used with a forged number plate, and the contact numbers given led to contact with one Abdul Malik, who was the owner of a different vehicle. Additional PP objecting to the grant of bail at this stage submits that investigation, though the present petitioners are not the main, they cannot be said actually, no, main accused. Anyway,
They are the part of the conspiracy.
that the investigation is revealed that the present petitioners were part of the conspiracy and assisted and abetted and assisted the commission of the alleged crime by providing SIM cards. The police is investigating into the matter.
Another, Lordship.
Yes, please.
Petitioners are the persons who, Lordship, assisted the police also to recover the items, Lordship. This is also mentioned in forwarding report. Last 3 lines, page 13.
After arrest.
After arrest, even, Lordship, they had assisted the police personnel to recover the items, Lordship. Last 3%, they have cooperated with the investigation, Lord. Page 13.
The learned petitioner council submits that the petitioners have rendered their cooperation after arrest and helped the police in recovering materials. It is submitted by prosecution that apart from active investigation still in progress, all the stolen materials have not yet been recovered. Stop. At this stage, I find force in the contention prosecution. Accordingly, the bail petition stands rejected at this stage. Return back the case diary. Let the investigation go. 22.
22.
Yes.
May I please your lordship? Lordship, regular bail application, lordship.
Yeah.
And I am behind the bar since 13/9, lordship. Today is 87 days, lordship. And statutory period is 90 days, lordship.
So we'll take instruction, my lord, whether in this case, charge sheet has been submitted.
Just a minute. Charge sheet has not come. Sorry, the
The
CD,
information we have not received, my
CD
lord.
has not come.
My lord, no, CD has not come, my lord. But can it be tomorrow, my lord?
Can be tomorrow. Can be tomorrow. Previous heard kind of allegation. The accused is stated to have been arrested on 13/9/2025, thereby completing 87 days in pre-trial detention. Case diary is not received. Case diary will not come tomorrow. Right? It will not come tomorrow.
We'll just get the information while investigation is.
Learned additional people seeks to take instructions about
Or
the
day
state-
after, or day after.
status of investigation.
After tomorrow, already 89 days, then I have to withdraw
89,
the
90 days
petition.
is there.
You will get default bail then, my lord.
Yeah,
Today is
still-
87.
petition is still
So
time.
here also we can give you that date. 89 days.
Then it will be tomorrow, my lord.
This will come in substance. Release the matter tomorrow.
Obviously.
You can also tell him that
Yes.
if he
We'll
has
obtain-
he can send the which police station.
Wrong, my lord. So that is why we'll obtain.
I don't know. Go near. You can send the case diary also.
Right.
Yeah.
My lord. Two grounds, my lord, I'm just levy for this on court. Number one, my lord, I was arrested on 16/11/2025. FIR dated 9/11/25. Now there is some allegation that I am the store in charge and a substantial amount of the goods which received in the godown that was missing. So therefore, being I am clerk of the organization, so therefore the earlier 409, that allegation
are
is 7 years
suspected
imprisonment,
and
my
you are
lord.
prosecuted.
Yes. So that's I am not on the merit now on this is because all those allegation is required to be tested in the trial. But these grounds and second, the most important ground is that I was not served with a notice under section 47. The police has served a notice which purportedly says under section 35 of the BNSS, which cannot be 35. It has to be 36. Be that it may, Lordship kindly appreciate the section 36 notice is quietly different from section 47 notice.
Yeah.
36 is preparation of memorandum of arrest. There is a physical act of the police officer and there are the duties of the police officer. This is the arrest memo. Man. And 47 is quite different. It's a newly introduced, which says that I have to be informed the communication of the ground of arrest as well as my right to bail. Lordship may perhaps have gone through this recent judgment of 16 delivered on 6/11/2025. The Mihir Rajesh
Not fully.
Shah.
Partly. Yeah. There are big pitch.
That's the latest judgment. Para 56, my lord. The last conclusion by the court.
Para 56.
Yeah. Yes.
Conclusion.
Yes, conclusion.
Yes.
The constitutional mandate of informing the arrestee on the ground of arrest is mandatory in all offences under all statutes such and such. The ground of arrest must be communicated in writing to the arrestee in the language she understand. That's a very important. In case where the arresting officer is unable to communicate the grounds of arrest in writing on or soon after arrest, it be so done orally. The said grounds be communicated in writing within a reasonable time, and in any case at least 2 hours prior to production of the arrestee for a remand proceeding before the magistrate. Otherwise, in non-compliance, the arrest and subsequent remands being rendered illegal. Now it's admitted the 47 notice was not served. So B, on the, taking into consideration my detention, I was in 5 days police remand. Thereafter, I was completed, my lord, on today, 22 days. So therefore,
He was arrested on 13.
on 16/11/2025, my. So the custodial interrogation further, for the purpose of investigation, so far I am concerned, my lord. And I am the main accused. There's no other than me, my lord. There are various sections inserted, but the substantial section is this section 4, agreement 306 now, BNS. There is earlier 4091. In fact, this new BNS was very difficult to in memory, my lord. So we have to relocate our memory with the RDL. So therefore, I am on the ground of legal ground, my lord.
I'll see.
Whether the 47 notice is there in the CD or not, that so far I am informed, my lord, instructed by the client, my lord. The 47 notice was not served.
My lord,
You go on submitting and then
in
I'll.
this, in this case, my lord, the IO has collected sufficient materials against him, my
That's,
lord.
I'm, that's
And for that purpose, Lordship may kindly peruse, my lord, second page and third page, my lord.
Oh.
Second and third page, my lord.
I am on the not on that ground, my lord.
Second and third page.
Not on the merit, my lord.
Because my said, my lord, the materials who has been, my lord, misappropriated, my lord. That is, my lord, more than a crores, man. Third page as well as the second page.
Lordship, kindly have a look that whether 47 notice.
Yeah,
My lord,
Yeah,
for
that-
that purpose, my lord, Lordship may kindly peruse the order dated 16/11/2025.
That's not
16 I have
speaking
my
about
lord.
anything. That we annex, my lord.
16/11 second page, my lord.
There is no,
The IO has contended, is opposed anyway. Let's see. I'll just come to it.
we have received a notice under section 35, my lord. That is the arrest memo.
Arrest memo has sufficient, it has grounds of arrest.
Yeah,
Where is the 47?
Everything is there, man.
47 notices there.
47, 48, 35, everything is there, man.
The 47? What? 47 we have not received, so
47 notices here. It is part of the. You said 48 notices not there.
The 48 is also there, man. Before the 47, there is a 48.
whether that has been received by us or not, my lord, that's the, because so far my instruction is concerned, 47, 40.
Signature is there of Dipankar Dev.
Okay.
And anyway, its notices are okay by and large. It's okay.
Because I have found the order, my lord. This is why I have verified the entire case diary.
Mhm.
I have found the
Yeah, which order
16/11
you want me to see? Which order?
16/11/2025, my lord. I have flagged it, my lord.
Of this court.
No, no, of the trial court. The trial court, yes.
Okay.
16/11, my lord. Lordship may kindly peruse the second page, my lord.
Okay. It is there, my lord, in the order.
It's okay. But on merits, there are some materials.
Yes, yes. There is material similar. Naturally, I am the store in charge.
Yeah.
So I have to explain that how this, I received the consignment.
Out of 1500, only 190.
Yes.
190 bags.
Yes. This is also subject to trial, my lord. I was not, my assignment duty is 7 to 11, then 3 to 7. That's my assigned duties, my lord. Otherwise, the some other persons are in charge. Though is a subject to trial. Now, my lord, can we consider whether my further detention, whether there is anything remains in the investigation?
I was written some, let me see then.
Yes, that's.
Notices are, I think, by and large, okay. They are okay.
That's
There
fine.
there- there may some investigation, my lord, and he is appealing to the informant. my lord.
Company. Company. Okay, I'll hear you. Just.
Yes.
I always said that investigation is a crucial stage and he seeks some time. No, and so praise for not allowing bail. Anyway, you submit.
Lordship, the FIR is very clear, Lordship. Actually, we are supposed to, Lordship, deliver a consignment to Hindustan Unilever Limited, Lordship. But Lordship, they have reported that 76 metric ton, total 1,520 bags were missing, amounting to, Lordship, around a crore, Lordship, 1 crore, Lordship. Now, Lordship, the Hindustan Unilever Limited, the authorities are pressurizing us to deliver the Lordship consignment, the property. And he being the Lordship supervisor since 2018,
Warehouse belongs to your company.
Lordship,
Your company.
warehouse belongs to our company, Western Carrier.
And you were carrying for Hindustan Lever.
Lordship,
Unilever.
Lordship. We have an understanding between us, Lordship. And Lordship, they are now pressurizing that the party should be, Lordship, delivered.
You are in a soup now.
Yes, Lordship. And Lordship, the petitioner being a supervisor, Lordship, since 2018, Lordship, he received the consignment. And his endorsement is there, acknowledgement is there, Lordship. How could it be possible that he doesn't know, Lordship, that that was huge quantity, Lordship?
First of all, my lord, I'm saying that I'm not at this stage on very merit.
Lordship, then 22 days also, Lordship. I was seeking.
No,
Lordship.
if a person say falls in such a situation, suppose it's taken matters, it is necessary on his part to give an explanation.
Lordship,
That
he failed to.
I was not there, or this was there, or stolen, or anyway.
And since till now, Lordship, nothing has been recovered, Lordship. And as far as my instruction is concerned,
Nothing
Lordship,
recovered.
Nothing recovered. As far as my instruction is concerned, Lordship, he has misappropriated the entire, Lordship, that consignment, that those things are products, Lordship.
Anyway,
Nothing is recovered, Lordship. We are, Lordship, answerable to the company, HUL.
that is true.
Now we are in a tight corner, Lordship.
We having an office, my lord, this company, my learned friend is appearing, they having an office inside of the godown. Near to godown is the admitted position.
Investigation, let it complete. Let it not complete. Let it progress a little bit.
Yes. And Lordship, there may be a nexus involved, Lordship. He, as far as my instruction, Lordship, he has sold it to someone else, unauthorized person, Lordship. They have sold it, most probably, Lordship.
Anyway.
The nexus should be, Lordship, unearthed.
Learned counsel and so and so for informant, RJ Borgo. Bail petition under 483 and Tinsukia PS case number 392 of 25 under so and so section. The accused was arrested on 16/11/2025. The gist of the allegations in the FIR dated 16/11, 15/11, 16.
9/9. FIR is on
9/11/2025. Is that
by 16?
A significant portion of goods that were kept in the warehouse to be delivered to Unilever company when were not found, and amounting to rupees 1 crore, and that the present petitioner, the accused petitioner, was the supervisor and storekeeper, supervisor of the said warehouse, and it is alleged that he has misappropriated the amount. The learned counsel, the petitioner, clearly submits that at this stage he is not so much on merits and contends that perhaps the notices, statutory notices required at the time of arrest may not have been punished properly. The additional PP, learned additional PP, submits on the basis of the case that investigation has revealed implicating methods against the petitioner. And
may I just intervene? I'm sorry. May we stay, my lord, before this honorable? I am in custody, my lord.
Mhm.
22 days. And further custodial detention, whether whether the status report is to be
Just-
submitted before this court. If it is,
Learned
yes.
Petitioner Council further submits that the petitioner has been in custody since his arrest, and during which it's in custody since his arrest, and during this time he has also been in police remand for 5
for
days,
5 days, my lord.
during which he was custodially examined. The learned counsel appearing for the informant, supporting the prayer of the prosecution, opposing the bail, also contains that as per their instruction, the petitioner has misappropriated the entire amount, and that they are facing pressure from the Unilever company to deliver the missing goods, and they are facing difficulties on account of that. It is submitted by the prosecution as well as the learned counsel for informant that the goods, allegedly missing goods, are not yet recovered. I have perused the relevant portion of the case diary. I find that the notices and the arrest memo, as well as the notices on the 47-48 BNS, enumerated 8 grounds of arrest, detailing the circumstances. In my considered opinion, the notices in the instant case would meet the requirements under section Article 22(1) of the Constitution, and the principles laid down by the Honorable Supreme Court in this regard. The IO has filed a bail objection, strongly objecting to the grant of the bail. The investigation is stated to be at a crucial stage, when involvement of other persons is being ascertained and goods yet to be recovered. Upon considering the materials and hearing the counsels, I find force in the projection of the prosecution / IO in this at this stage, and accordingly the bail petition stands rejected at this stage. Return back the case diary after some time.
Oblet. Get for me.
Oblet.
My lord. Yes, 60 days offense, my lord. Today is 59 day. In fact, on the last occasion, while rejecting the bail, your lordship said to approach after few days, my lord. Therefore, my lord, we file this today is the 59th day, my lord. 24. I think 59 day, not good. 60 days offense, my lord. No penetrative and nothing of that sort, my lord. Still in the realm of allegation that some video call was made.
Informant, you are appearing for the no.
Wait, this is my lord. I'll be appearing for respondent number 2, that is
Yes,
informant.
that's what I asked. You will come
Yeah.
this side. I'll hear you. Come to you. Let him come, please.
So, my lord, 59 days, my lord, and 60 days offense, my lord. And the allegation does not pertain to any penetrative sexual assault, my lord. The allegation is that the accused have made some video calls, and there was some attempt, my lord. But no hue and cry, nothing, my lord. Be that as it may, my lord, my defense I'll disclose at the time of trial.
Today we have not received the case diary, my lord. Since it is at 59 days, my lord.
We'll
Let
fix
us-
it the
let
day
us-
after tomorrow.
Let
But
us
day
take
after
instruction,
tomorrow-
my lord. Let us take instruction.
Hmm?
Or day after tomorrow.
Day
my
after
lord.
tomorrow, you check on that day whether
Yes.
charge sheet is
But day
submitted.
after tomorrow, already he will be entitled for default bail.
Yes, he will be entitled on default.
So let it be tomorrow, my lord, because 60
No,
days will
tomorrow
be
we have
tomorrow.
60 days we have time, my lord.
Yes, till
60
5
days is not his, my lord. 60 days
No,
is
my lord,
summer.
cases
61
police
days
should
will
be
be.
given
My lord,
full opportunity.
probably my lord, the learned public possess 60 days, my lord, for 60 days, my lord, because he's approaching the High Court for the second time. 60 days, my lord, he can always go to the magistrate
The
before.
court cannot give you statutory bail before the statutory period, right?
No, I'm not asking for even otherwise also, my lord.
Merit, no, because for that we need to see the case diary because it was registered.
59 days, my lord, whether for
Oh, so only on the ground of detention.
yeah,
No, I think that
detention,
will-
because tomorrow, by tomorrow, it will be his fundamental right, my lord, by tomorrow.
No, not tomorrow, day after.
Day after tomorrow.
The right starts after completion of 60.
60 days.
The right is mature on the 61st, 91st day.
61st day, I understand, my lord, because
91st day, actually after 5 p.m., but usually it's for practical things.
let it be tomorrow, my lord, at least, my lord. Because only a telephonic instruction needs to be taken.
Tomorrow or day after.
Kali korilo, khali telephonic instruction.
Actually, in my opinion, it should be because we should follow a uniform standard. If we are seeking whether to give default bail or not, it should be on the 61st. Day after. Full stop. The prosecutor learned additional PP shall take instructions regarding the status of investigation and as to whether charge sheet has been submitted. The accused is stated to have completed 59 days as on today. Madam, sorry, what do you make your submissions? Also,
My
for-
humble submission, my lord, tomorrow, if even the certain is not filed tomorrow, my lord, Lordship cannot grant him default bail, my lord.
Tomorrow
But on
default bail
behalf
cannot
of
be given.
tomorrow,
That is
my
why I
lord,
fixed.
Yeah, that is why, my lord.
My lord,
The Lordship will
On
have to
60th
consider
or
bail
90th,
application
default
on-
bail cannot be given.
My lord, I have,
Merit bail can be given.
my lord, I have not applied this under that default bail section, my lord. It is
This
basically,
default bail section, it's
I have not applied it before that
But
default bail
anyway, my
section.
lord, we'll take instruction, my lord.
My lord, that is why, my lord, I was praying that if it could be tomorrow, otherwise also I'll have to collect the certified copy and I'll have to send it to this, my lord, Durhat.
Tomorrow
Dhubri,
is
sorry.
considered on merits and new grounds. Okay, tomorrow. This is the matter tomorrow. On merits and on new grounds. And you also take instructions
My lord.
regarding the status of investigation. Okay.
60.
In any case, it will be towards the end of the day since it
Yes,
is
my lord, that is-
supplementary list. By that time, you can take a realistic instruction. No issue.
I'm deeply obliged. I'm deeply.
Wait, please, your lordship. Lordship, this is the application under section 483. He is behind the bar. They are behind the bar for 250 days. Already charge sheeted, your lordship. Trial has begun, your lordship. No materials as such, your lordship.
POXO matter? No.
No, your lordship. These are only 354, 342. Maximum punishment 3 to 7 years.
Lordship, scan copy has come, my lord. I have scan copy has come, my lord. Lordship may peruse the, my lord, victim statement, my lord. Our 183 statement is not legible, my lord.
Oh.
But Lordship may peruse our 180 statement, my lord.
This is just not legible.
Already, lordship, charge sheeted. You will pay.
Yes, sir. Cannot read it.
180 is not there.
164, 164.
Oh, yes, my
I
lord.
tried.
That is not legible, my lord. My lord, perhaps, my lord, both
Someone will be able to read it.
180, my lord, Lordship may peruse.
164, I have seen, your lordship. After about 1.5 months of the incident, it was recorded.
But the incident that has occurred, my lord, is a matter of grave concern, my lord. A guard was molested inside the bus, my lord.
Medical report has also come, your lordship.
Yes, very serious allegations.
Yes, yes.
Very serious, my lord.
Allegations are serious.
Serious allegation.
Lordship will
Guard was, my lord, quite intelligent, my lord. That is why, my lord, he has, at this, at that point
Disturbing.
of time, my lord, he has applied her mind, my lord.
I think we should adopt a strict view. This
No, lordship, he is behind the bar for 250 days, your lordship.
250 days.
250 days, already charge sheeted. They will face the trial, your lordship.
No, but the victim, the alleged act is notorious, not just.
No, lordship, then for a moment, lordship will also go through the medical report that has been submitted, your lordship. And I have also annexed the same because this have already been submitted to me during the the trial of the case.
Yeah, just make a try to peruse the 164 statement from the scan. Can you?
I've not been able to go through, my lord, whether lordship can.
Someone
or not.
more skilled than us, maybe.
Actually, my lord,
In the earlier days used to be that translation wing, they used to have this big
Yes.
magnifying glass. They still have problem, but you can just see, you can, the later part also, if you can read, my lord. Otherwise, but the victim has not been examined or examined. That is a
Well,
crucial.
the trial has not proceeded yet, my lord.
The
My
trial-
lord, Amical.
Already 250 days, your
That
lordship.
is true. It took long time for investigation. But this is a,
No, actually, already charge sheet has already, charge has been framed, your lordship. The sections are 354, 342 and 34.
but the learned prosecutor, he's fairly submitted. It's the circumstances, it's very.
Yes, yes,
see,
yes.
the-
I also admit, your lordship. Had it been,
Yeah, you are doing a professional
No, no,
duty. I
I did-
appreciate your submission.
lordship, had it been a case that I have come before filing of the charge sheet.
It's your
I-
duty to,
Yes, your lordship. Since
speak for him.
lordship, since charge sheet has already been filed, your lordship, and the medical report I have annexed at page 15, your lordship. 15 for a moment. I don't,
Can you, but is it clear from this?
Yes, my lord, whatever stated, my lord, I am not reading by line, my lord. My lord, she boarded the bus, my lord. But he could not, my lord, he doesn't know, my lord, whether there is any person inside the bus or not. When she boarded the bus, she find that there was no person.
You have read the 161, right?
161.
So just see whether it broadly tallies. That is what we should check.
161 is also same, my lord.
Yeah.
161 is also same.
No, don't misunderstand me. I'm not prejudging, but this is also true that Nirbhaya incident have also similar to.
yes, yes. That is why they have not been granted bail, because once such type of allegation comes, your lordship, our
Allegation
mind.
is that, my lord, when she
She
boarded
was
the
very
bus, my
lucky
lord.
that she escaped.
No.
Yes, but see, my lord, at that point of time, my lord, she has applied her mind, she has sent the, my lord, our location, my lord.
To her uncle.
Then, my, yes, my lord. Then, my lord, her father came, my
I
lord.
don't even know how to send it. So
That is
that
the,
is
my
not
lord, incident, my lord.
reflected in the,
don't know. She knew.
Although, my lord,
And-
there is in the medical report, my lord, no such injury, my lord. That is, I am humbly submitting, my lord, no such injury, my lord. But there was an attempt, my lord, because they slapped her and they tried to pull her close, my lord. She became senseless, my lord.
Now, if it
After
is on
that, my lord, when she regained sense, my lord, they thrown out from the bus, my lord.
if it is on merit, lordship, may I submit, your lordship? Well, I am saying that since charge sheeted, your lordship, already everything is done. Charge has already been framed also, your lordship. I have annexed that order also. Now the stage is proceeding under section 294 CRPC, admission or denial of documents. That is the stage at which the case is pending, your lordship, right now.
Fair.
I'm fairly submitting that I have, on the day, immediately after the day of arrest, we are arrested, your lordship, and since then we are behind the bar. Charge has already been filed and charge framed, lordship will kindly see what are the sections under which charge has been framed. I have also kindly peruse for a moment, lordship, page 15, the medical report. But before that, lordship will go through the FIR once for a moment. That will indicate, your lordship.
Yes.
Yes, FIR at page number 10, your lordship.
Yeah.
May I read? It is by the father of the victim girl. Today at about 4:45 p.m., my daughter so-and-so had boarded a bus in front of Badarpur Circle Office while returning home. And as she entered the bus, the driver, along with 3 other persons, so 4 persons were alleged, had physically assaulted her and had also tried to rape her and take her life. After some time, I received information that my daughter was lying unconscious at an isolated place in Chargola locality. I immediately reached the place to recover my daughter and then took her to Karimganj Civil Hospital, where she is being kept under treatment. So regarding that, she had sent some location. I don't know from where this has come, but this is in short the FIR, your lordship. Immediately after the FIR, your lordship, on the same day she was being medically examined at page 15, your lordship. She was taken by the local people, your lordship. Page 15, and that is also a part of the record that have been received from the learned trial court below. Page 15, your lordship. On 1/4/2025 at around 6:35 p.m., the following named patient got admitted in the civil hospital by so-and-so. That is her description. The patient came with some unknown public. The patient was not escorted by police. The initial history was reported by the accompanying public, followed by the patient. She was admitted. Lordship is going to page.
Yes.
She was admitted with the history of RTA. On examination, vitals normal, no external injury found. The patient got admitted in the FSW and later on she was shifted to the ICU. In the ICU, she was examined by the ICU in charge at around 10:35 p.m. on 1/4/2025. That is the day of incident. As per her statement, she was allegedly physically assaulted inside a bus on which she was forcefully pulled in by some miscreants. I don't know whether at around 4:50 p.m. on 1/4/2025. Later on, she was pushed out from the running bus at around 5:50 p.m. and so and so. On arrival, vitals are stable, no signs of external injury, ECG, chest, X-ray, X-ray of dorsal spine, LS spine and pelvis, USG whole element, CT brain done. All the reports are within normal limit. The patient is being treated conservatively. The case has been admitted by the on-duty doctor, emergency room, and later on examined by the ICU in charge, orthopedic surgeon, and ONG specialist in the ICU. the final report will be given by the medical board. So absolutely no physical injury of whatsoever was found, your lordship. And then page 16, your lordship, was 16A. 16A, your lordship, confident it is sexual assault report, your lordship. Absolutely nothing has been found. I will not go through, lordship will see. Nothing. Now, your lordship, these petitioners, your lordship, they were arrested on the next day, your lordship. Lordship will kindly see the forwarding report. On the basis of suspicion, your lordship, they were arrested. Lordship will see the forwarding report at page 13 for a moment. Page 13. Lordship has got it.
Yes, page
Page 13, 13, Annexure 2, the forwarding report of their arrest, your lordship.
Yeah.
Now, lordship has brief of the case, lordship has got the second paragraph. That, sir, during the course of investigation of the case, 5 number of suspected buses that were found flying on the road during the time of the occurrence of the alleged offense have been rounded up for questioning based on the vehicle's physical description obtained from the CCTV footages of Badalpur PS. As such, the drivers and handymen of these 5 suspected buses have been brought in for questioning to ascertain facts for corroborating the happenings related to the alleged incident. During questioning, the involvement of the below noted accused driver and handyman have been found to be doubtful. Therefore, their detention and arrest have been deemed necessary at this stage of investigation of the case. So they have brought in some 5 buses, your lordship, drivers and handymen, and ultimately 2 of them have been picked up, your lordship. Now, my submission is that one of the petitioner is a driver of one vehicle and the handyman belongs to a different vehicle, your lordship. Anyways, they have been arrested on that day itself, and then the investigation carried on. Grounds of arrest, lordship has seen
any
nothing that
materials, just a minute, any materials regarding tower location? Because, because that will nail, if the tower location is found out, because he gave a live location. If the other 2 persons were in the same location,
yes.
Anyway, but in these cases, EIP should also be done. Nevertheless, what next should I see?
Now, your lordship has seen that on the basis. Now, why their arrest was necessary to identify or locate the main modus operandi behind the scene, to identify apprehension of other accomplice, to custodial interrogation for collecting more evidence. So for this record, they were arrested, your lordship. They were all along behind the bar, your lordship. Until today, they are behind the bar. And ultimately, a charge sheet came to be filed, which is at page number 19, your lordship. In the charge sheet also, there is nothing that something have been found against these persons. Lordship will find at page 26 is the gist of the charge sheet. Page 26, lordship has got it.
I've got.
Second paragraph, during investigation, the PO was visited and drew up sketch map of the PO. Same, your lordship. Informant and victim witnesses were examined and recorded their statement. Under the judicial statement of the victim was recorded at Honorable CGM Court. Medical examination of victim was done at Karimganj Civil Hospital, Sibugni, and collected the reports. After verifying the CCTV footage of Badalpur Police Station and other places, one vehicle bearing registration number so and so was identified, and accordingly, the said vehicle and its registration certificate and insurance certificate was registered by preparing Caesar list. Driver and handyman of the said vehicle on the date and time of occurrence was so and so, and they were arrested and then forwarded to the judicial custody. The seized vehicle and documents were released on Jimma as per order. In course of investigation, 2 persons were identified and accordingly they were arrested and forwarded to the custody, but other one could not be identified despite several attempts. Now, what they have found during the investigation, how their involvement has been, nothing, your lordship, that these 2 persons, basis of CCTV footage camera, they brought 2 persons and they arrested them, and now they are forwarding them, your lordship. Now, on the basis of this materials, your lordship, the Honorable Learned Court below, the trial court below has already framed charge sheet also. Framed charge also. That also I have enacted page number 30.
No,
your
I've
lordship.
seen.
And charges are, your lordship, all 342, maximum 3 years or maximum.
No, don't go by. Anyway.
Yes.
You can make your.
Now, my submission at this stage, your lordship, since already charge sheet has been filed, your lordship, they were all along behind the bar, and there is nothing, even as per FIR, that there are many other persons, no other person could also be traced out. Ultimately, charge sheet has been filed against them. They will face the trial, your lordship. One is a driver, one is a handyman, your lordship. Medical report does not at all support the case, your lordship. And then, your lordship, since already more than 250 days, whether further custodial detention will be required, whether there is anything, your lordship, that they will. They are poor persons, your lordship. They are the sole breadwinner of their family. I have given the birth certificates of their minor children also, your lordship.
My lord, my humble submission, my lord, it is a certificate case, my lord. So lordship will have to consider the application on merit, my lord. Now, what are the merit, my lord, the ground, my lord, they are taking. Now, my lord, lordship will have to rely on the statement of the victim girl, my lord, because she is the only person, my lord, who has, my lord, given all the details, my lord.
She has
to her
not
parents.
identified anyone, your lord.
No, my lord.
Correct.
That
She is
is,
the-
that is why, my lord, her examination as a.
No, therefore,
not
already
been
charge sheet has been
essential,
filed, your
my-
lordship. All the materials have
Charge
been
sheet is
placed
not
before the
end
London
the
Court
matter,
below.
my lord. Her examination before the court is
Third
important,
choice.
my lord.
Exercising, invoking 483, seeking bail, regular bail in connection with Badalpur PSK 6425. Which after completion of investigation resulted in a charge sheet and presently pending before the learned trial court. And charges are also stated to have been framed. The charges have been framed under section
Lordship. At page number 30, your lordship.
30 under section
127 to 35,
30,
74,
the
76,
petition.
75,
So
and
and so
65.
Full stop. The FIR has been lost by the father of the alleged victim girl with the allegations that she boarded a bus which did not have other passengers, and the driver and the handyman tried to molest and rape her, and somehow she could. Later, she was found in an unconscious position, unconscious state, and rescued by people. The learned counsel has submitted that the petitioners, having been arrested on
2/4/2025,
2/4/2025, spent
250 days as on today.
more than 250 days in custody. And the case is also at the stage of trial. Full stop. The statement of the scan record is available. It was the
It's here.
statement of the girl recorded by police during investigation. In which she narrates the incident on similar lines as in the FIR. He has also mentioned that the bus, though empty, had curtains on it. Curtains on it. It is stated that luckily she could send her live location to her uncle and subsequent live location to her uncle from her mobile phone. The learned additional PP opposes the bill strongly, considering the serious nature of the alleged nature and manner of the alleged offense.
And my lord, examination of the victim girl is very much
The
important.
learned counsel, he also
Before
admits
consideration
that
is bail application.
examination of the victim girl is very much important. And bail should not be considered at this stage. The learned petitioner counsel, on the other hand, submits that they have already spent a considerable time in detention and they shall face the trial. I've given my anxious consideration to the materials on record and also the submissions of the counsels on both the sides. Full stop. Undoubtedly, the length of detention is on the higher side, and investigation is also at the stage of the case is also at the stage of trial. However, it is true that, as rightly contended by the prosecution, the manner of the alleged offense is indeed very serious and it would be prudent to allow the examination of the victim and
Any conditions, lordship?
other crucial witnesses like the
They are behind the bar, your lordship.
accordingly, I'm constrained to reject the bail at this stage.
Lordship, may
Return back. No, let it be.
allegations are not of serious, but they have not been identified. Nothing, your lordship. FIR, no.
Anyway, you've done well. You've tried your best. Never mind. After some time.
I am obliged, lordship.
May I please, your lordship? Lordship, here the petitioners are on interim, lordship. And today is the 11th date that CD is not issued, lordship. Interim was granted on 17/3/2025, lordship. FIR is of 30/11/2024, lordship.
They were arrested on?
Not arrested. This is an anticipatory.
Oh, bail hearing.
No, they actually told, no, earlier, my lord, case that he received, my lord, then it was, my lord, sent for up to date, my lord.
It has come?
After that, my lord, it has not come, my lord.
Today is the 11th date, lord.
Is it?
Yes, from 17/3/2025.
Moreover, he's on interim also.
Interim.
Helps him, but still, he should. Oh, yeah, long time.
My objection may be recorded.
No, no, get it, get it. No, no.
My, yes, yes, my lord.
Get the case.
Yes. Before
Long
vacation,
time.
we'll try, my lord.
Long. Why?
Sorry,
It's,
They are on interim, my lord. We can fix it after vacation, my lord.
They are
Because,
on interim.
yes, my lord.
Yes, interim.
Because before vacation, my lord, several cases has been
You
fixed. my
know,
lord.
see, the thing is that there are various, various things can work at
Yes, my lord.
many forces can be at work. See?
My lord.
So don't, don't allow the IO to delay.
My lord.
Because lordship, incidents are of 2 dates.
Yes,
And
but-
FIR is on,
but
FIR
He's
is on.
benefiting by the continued interim, but he seeks disposal.
Yes.
That's fine. That's good on your part. So.
One last chance, my lord, after that.
Yeah, but because see the thing, I'll also be violating one direction.
Yes,
You know that this also recent certain until another recent judgment,
Glance.
4 weeks, regular bill 4 weeks it has to be disposed.
Only, my lord, we have to verify, my lord, whether investigation is completed or not. my lord. Investigation might completed also, my lord. So that is why, my lord, we request.
FIR is of lordship 30/11/2024. Interim was granted on 17/3/2025.
He is on interim, madam, nothing to worry. He will not be arrested.
Still, as I said, there
I'm just
can
saying
be
about the last,
many
last
forces
chance.
at work. As I said,
Last chance, my lord.
there can be sometimes.
Before vacation, lordship, 19th.
No, no, that will be after vacation, my lord, on 9th, 9/1.
The petitioners
Are on time.
were granted interim bail on 17/3/2025. And case diary was called for. But it is distressing that the IO has not sent the case diary till today. As per the direction of the Honorable Supreme Court, the bail petitions are required to be disposed of expeditiously and rightly so. Therefore, the IO is directed to positively send the case diary on the next date, failing which the court might be constrained to take exception. A copy of this order shall be sent to the OC of the concerned police station. The interim bail stands extended till the next date of listing, fixed on
9/1.
9/1.
Obliged.
39. My lord, case diary not received.
Milord, in several dates, case diary was called for, but on last date, a strict order was also passed, but no response from IF. Milord, there is a Azhar, Milord. There is no element of section 69 of BNS.
The petitioner was granted interim bail on 29/7/2025. Stop. And CD was called, case diary was called for, but till date his case diary has not been received. Here was the last order. 27/11/25 passed by coordinate bench, stating that default to produce the CD today, the IO may be called for his personal evidence. The case diary is not available today also. The case diary, and the IO shall positively send the case diary on the next date, along with a explanation as to why the case diary was not sent since the first date fixed on 8/9/2020. A copy of this order shall be sent to the OC of the concerned police station. Interim bail stands extended till the next date of listing. That will work. That might work a little bit.
My lord.
That personal appearance, last option. Right?
Let me on, my
They
lord.
have time, nor we have time. But he should,
My lord,
at
night.
least, if he has to write something, maybe some.
Next date is, my lord, 8/1, my lord. 8/1 next.
All right. 8/1. You see, if there's some genuine difficulty, it should be.
My lord, my lord.
It should be told the prosecutor. But case diary, we are not asking for a detailed report. Case diary has to be just packed and sent. Nothing.
31.
May I please, your lordship, my lord? PRH bail petition is a interim, my lord. Up to date case diary was called for, my lord.
Yes.
My lord, allegation in nutshell, my lord. Petitioner is a dentist, my lord. I have no valid dentist degree or registration, my lord. My lord,
Dentist, আচ্ছা, আচ্ছা।
dentist, my lord. My lord, this affair is the July 2024.
Dental surgeon.
Subsequent to this, my lord, affair, another affair was filed, my lord. In that affair, the petitioner was arrested, my lord. My lord, I take a lordship that affair, my lord. And same allegation, your lordship kind enough to pass an interim order, my lord. And that is on, my lord, page 26, annexure 4, my lord.
In this case, right?
My lord. No, my lord. The subsequent, in the year 2005, 25. Because of the professional library, my lord, this one after another, my lord, after. And para 5 of your lordship order, my lord, this is my stand, my lord. Now, subsequent to this, in that bail, my lord, this honorable court make it in absolute, my lord. This is the order, my lord. Now, I have already put behind the bar, my lord. And this case, my lord, I have all, by virtue of the interim order, my lord, I appear before the IO. My lord, cooperate with the investigation, my lord.
Where is the final order?
My lord. Cooperate of the investigation already. Since it is documentary evidence, my lord, Apex Court already, my lord, in the 2025 also judgment, my lord. Since they are related to documentary evidence, my lord. So, my lord, bail may can be absolute.
Yes.
And once I already have arrested on the same sets of allegation. The informant is a two different body.
For the narration, I wrote something in the earlier order.
Mala.
Rightly or wrongly.
That
was
is
submission, but,
Mala.
there was
And
a-
I have annexed all the
no.
documents.
Yeah. You're saying that Kalka Dental College.
Mala.
The Charan Singh University, Meerut.
Mala. Even recent RTI report I have an annex. That is all authentic and genuine. Just professional rivalry, Mala. This.
But professional rivalry is everywhere, isn't it?
Mala.
It's not with regard to any particular person.
Mala.
It will be, then we are also friends. That's like that.
Mala.
Like in the-
Absolutely.
But that will, filing a criminal case,
Against.
if it is due to professional, it's extremely bad, disturbing. But the thing is that if there's something else, then maybe. Otherwise,
Mala, I have
normally people will not go to that extent, right?
And one other aspect, Malad, that they want, Malad, I have to register under the Assam Dental Council. Malad, as per law, Dentist Act, Malad, 46, Malad, it is not required. Once register under any dental council, it is not required. My registration under Maharashtra Dental Council. Now, recently, Malad, in between, Malad, this interim order, Malad, 2 documents have been supplied, Malad, by the informant itself to the petitioner. Perhaps maybe in the part of the diary or not, Mala, I do not know.
You see that?
Mala,
any
Mala. I
document
take a
submitted by
lordship.
the informant.
Mala. One letter of the 6/5/2024. Mala, I have registered under Maharashtra State Dental Council. Now, in that letter, Mala, it's since it's after the filing of the bill, Mala. Maharashtra Dental Council, Mala, wrote a letter, Mala, to the Assam Dental Council, Mala. Mala, may I read, Mala? Regarding the subject mentioned above, it is informed you that individual name S. Islam Chaudhary and J. Hussain have been fraudulently registered with the Maharashtra State Dental Council through unauthorized access to website. A complaint has been lodged with the local police station against them. Now, this as Islam Mala, his honorable court has granted him bail, Mala. Now I'm coming later on, Mala. I'm sorry to say, Mala, handing over one of. Now, this report is 2024, Madam. That was interim order, but subsequently the final order. which is mentioned in that report of the Maharashtra State Dental Council. Now, I have applied, my brother applied RTI report, page 53 and except 21, my lord. May kindly be bearers. Information sought under such and such. Please refer to such and such application addressed to the public information officer such and such, the information with respect to your query such and such. It is informed you that individual such and such, son of such and such, registration number such. Please note earlier mentioned such and such is valid and bona fide resistant with the Maharashtra State Dental Council. Now, this report is recent, my lord, July 2025. So that letter, my lord, we do not know, my lord, who is the significant authority. Only J. Islam is written, my lord. Here the registration number, my lord. If your lordship find, my lord, in the Dental Council website also, my lord, I have annexed also the, it is the postal envelopes, those who, my lord, sent through us. My lord. In the, if your lordship kindly see the Dental Council, my lord, website, my lord, it is also there that the petitioner is.
Where is it? Which
my,
page?
my lord, my lord,
Page?
my lord, that is before that, my lord, I take ownership page 38 annexure 11. This is the same Dental Council, my lord, page 38 annexure 11, my lord.
Online application.
Online
Application.
My yes, my lord. My registration is valid up to 31st December 2025. It is online application, my lord. There is no scope of, my lord, that type of, my lord. Now this letter from where we have, my lord. Now followed by, my lord, that we have searched in the Dental, my lord, Council of India website, my lord, page 40 annexure 13. My lord, kindly see the registration number mine. Register on that.
That's why interim was given anyway.
My lord.
What was the
Now, my lord,
investigation?
what I since it is documentary evidence, my lord, I already in the another case I have already arrested. This honorable court grant me bail, my lord. I have been thoroughly investigation. Assuming, my lord, in the charge, my lord, in the charge sheet, if they file, my lord, I have to face the trial. My lord, for example, my lord, I am citing an example, my lord. Suppose my friend laws an affair against me, that my law degree and the registration under Bar Council is a theft. Well, is it not the duty of the police officer to investigation in the Guwahati University or the Bar Council of India? One, instead of doing, well, and since already in the Navy, one is Howli, one is Borpeta. Your lordship granted me bail in the Borpeta. In that case, well,
You're right.
already up.
That is all right.
One EPSCO judgment.
Investigation should be there. That
Yes,
side
my lord,
also,
sir.
that also should be one part of the, anyway.
Yes, my lord. My lord, we have received the case, my lord. So investigating officer, my lord, he has obtained report from two university, my lord. One is Calcutta Dental College, my lord. That is from Mirat, and another is
Calcutta
from, my lord.
College is a genuine college.
My lord,
Genuine
they-
college.
No?
It is genuine college. That's why they have submitted a report, my
Because
lord.
I've come across
And
the name.
secondly, my lord, Maharashtra State Dental Council, my lord, and both the reports says, my lord, the petitioner enrollment is fake. There is no such candidate in the name of, my lord, Ziarat Hussain, my lord. His name has been specifically mentioned, my lord. So, my lord, report goes against him, my lord.
But how
So-
come the RTI was given?
Well,
That would do.
perhaps that report, what my learned friend relying, my lord, 10th of July.
Is it a
2000
case of registration? But later it was found that registration was done fraudulently. It is, that can be one scenario. Otherwise, this document, this is to certify
my
that
lord, this from
registration
the-
of dentist
From the
Ziarat
report
Hussain
is report of
is
Maharashtra
renewed
Dental,
on so and so, remain in force till 30. Okay, fine.
report of State Dental College, that is on dated 6/6/2025, my lord.
Mhm.
Yes.
In this report says, my lord, there is no sub person, my lord, and it is totally bogus and fake also, unauthenticated and unreal.
My lord,
So, my lord, report goes against him, my lord.
my lord, that's why I'm relying that, I'm reading that report, my lord.
Yes, my lord, that
And
is
it's
why-
a RTI.
He says, my lord, is a document. The document goes against him, my lord. That means, my
This is
lord,
the report, Tayo.
there is a report, my lord. IO has sought for a report, my lord.
The report was
In response to the yes, the report has been received.
Let me have a,
Yes, my lord.
how come? Then?
My lord, that
And
is,
website, this website thing,
my lord, even website also, my lord. Internet, my
No,
lord.
as I said, this I can understand that the registration was done,
My lord.
but done fraudulently. Later it was found to be done fraudulently. It's another.
My lord, page 53.
But I think one informant document, I think said that only, that fraudulently registered under Maharashtra Council. You had read once document, informant,
Yes, yes.
that fraudulently registered under Maharashtra Council.
Maharashtra.
My lord, it is in the
Okay,
FIR.
that is my lord, two report, my lord. One is light pink color, my lord, and one is dark pink color.
Light pink, dark pink.
Yes, my lord. No, my lord, that is
Partially
otherwise
colorblind.
lordship will be confused, my lord.
Green is worse for me, but I just cannot recognize green. Right?
I have also
Partially
mentioned
colored.
in the report, my lord, report.
Perhaps one is 10 July 2024, issued by Principal Kalka College,
Hmm.
and another 6/5/2024, issued by Maharashtra. And my RTI, my lord, in the year 2025, July. My lord, this report is
Yeah, whether
under.
this is an original document. Original document.
My lord, I have the
Whether
original.
Ziarat Hussain studied BDS at
My
your
lord.
college, no such student studied.
My lord, or my lord, if your lordship, the all original document with me, even the RTI report with the envelope, all everything.
If RDA report is also fake, then
My lord. No, my lord,
no. I mean, because these, how can they say two contradictory things, right? One of them has to be wrong, right?
My lord, that is why.
You get my point?
My lord,
Obviously.
absolutely, I
Whatever
appreciate.
has been given to
My
you,
lord, I
you have
appreciate.
submitted
My
on the
lord, my
basis
lord,
of that.
that RTI report is subsequent to this report are in the year 2024, my lord. People lordship kindly appreciate. And my RTI report is in the year 2025. Because I have studied, I have passed from I have annexed all and these are the all
Reference
documents.
to the
Even assuming a given case, my lord, thought, my lord. Now I take ownership the EPSCO judgment receipt, my lord. In a case of the documentary evidence, my lord.
totally, it's all
Custodial interrogation already
complete
happened
bogus.
in custodial, my lord.
Bogus. No?
My
This
lord.
is complete bogus. The
my lord,
Maharashtra Dental Council said that this identity so and so is completely bogus.
my lord, my lord.
So he may have faked all the documents.
My lord.
That is that is true, custodial. But the thing is that see, suppose we practice law without any degree, it is not. It will be fraud on the public.
That is
isn't
true.
it?
I appreciate that is true, my lord. People lordship kindly,
That's okay.
kindly appreciate that, my lord, the original, my lord. That very institution, my lord, maybe, my lord, kindly see the original.
That is the only explanation. That if this is genuine, then that is fake.
Yes, my lord.
He has manufactured everything. If this is given to the police,
my lord, that
so they cannot, nobody would dare to give
my
a
lord,
fake document.
I appreciate, my lord. In another way also, my lord. My lord, kindly see these documents also original supplied to the RTI, my lord, with all my lord documents RTI. So assuming, my lord, it is a case of the, my lord, trial, my lord, whether it is in either way, my lord. So in that case, my lord, I take your lordship the one judgment of the apex court, my lord.
Just a minute.
My lord. Yes.
Mr. Borua, can you have a look? This is really perplexing.
My lord.
This is supposed to be an original document, of which he has, for a copy, he submitted with the petition.
My lord.
On the face of it, it looks like an original document. But the document supplied to the IO, which you have narrated, it says that complete bogus. Nothing is there.
Nothing is there.
My lord, I do appreciate. At the
think I'll
same
give
time, your
some
lordship
time.
kindly appreciate.
I think
Even then, my lord, in the same sets of allegation, I have already arrested and put behind the bar almost month. Then after this,
The
honorable
question
court
is that,
released
my
me.
lord, we cannot rely with this document, my lord. Because nowadays, my lord, everything is possible, my lord. Because everything is possible, my lord.
that is
assume my learned friends
if we have to say that, Borua,
Question is
you'll
that,
agree that everything is possible nowadays in our world,
Yes.
then it's very unfortunate. We have to change that.
No, my lord.
The
question is
checks
that,
and
my lord-
balances have to
No,
be
no,
stronger.
my humble
We
submission,
have
my
to
lord.
make it stronger.
Now, my humble submission, my lord, I have sought for a report, my lord. Pursuant to that report, my lord, the University Dental College of Maharashtra and Mira, they have supplied, my lord. Stating that, my lord, both the universities say same thing, my lord. The student is not belong to our university, my lord.
In both they contradict, my lord.
Now, my lord, he has placed.
Even
his
then, my lord,
document. Let him, madam, let him place his document before the executive.
I have gone there, my lord. I already submitted, my lord.
But interim is there.
Question
Even
that,
is
my
that,
lord,
may be
that, my lord.
approved, my lord.
He has produced the document that we cannot rely, my lord, because we are not the authority, my lord, to verify all these documents. my lord.
My lord, that also issued by the your lordship.
Anyway,
kindly.
I'll need some time. I'll keep it inside. I'll pass it after.
My lord, one judgment of.
Yes.
May kindly be. my lord.
Because
Lordship will say, in the case diary, my
Go
lord.
fast.
My lord.
Yeah, I'll pass it today only.
My lord.
I'll be here till late.
My lord, your lordship, one judgment of. Just I'm reading one paragraph. huh? 2025 judgment, my lord.
Yes.
My lord, I pass it.
Yes. Keep that judgment.
Considering the nature of allegation and the fact that the matter is to be investigated primarily based on documentary evidence, the court is inclined to grant the relief of the anticipatory bail to the appellant. It is a settled position of law that the anticipatory bail can be granted where the custodial interrogation is not essential, particularly where the case allegation has a use in official records and presence of the accused cannot be secured without the pre-trial detention. Now, on the
No,
same.
not only there is a subsequent decision which says that that is true, because that is how we traditionally understand. But there's a recent judgment I also learned that, and the Honorable Apex Court has said that there's a they call it almost misconception that it is only for it has anticipatory bail has all the trappings of a regular bail order. But in that case, he is not arrested. Here he comes out of custody, but he remains on the bail.
But on the same steps of the case, I have already arrested. No, further again, it's just like a jeopardy. Kindly that aspect also. I have already arrested.
Not really. I mean,
In the subsequent
I'll see,
case.
that's why I'm taking some time. So
Your lordship order is there, final order is also
do justice to the matter as well as to speed up other matters waiting counsels.
32.
Yes.
Hello, bless.
Yeah,
Must. Any condition already the man is get
Yes,
little
conditions have to be imposed. If
mild stroke also, man, because of this and anxiety. Mild stroke. Basic.
My lord, in this case, we have received the case diary, my lord, but without the medical report, my lord. So he is on interim, my lord. We will call for up-to-date case diary.
Lordship, here in this case, all are available section except 353(3), in which the case has been registered.
353 subsection 3 BN.
Subsection 3.
What is that?
Subsection 3.
Sorry, I'm having to ask you that because.
Yes. This is with regard to the fact that whoever commits an offense specified in subsection 2 in any place of worship or in any assembly engaged in the performance of religious worship or religious ceremonies shall be punished with imprisonment which may extend to 5 years and shall also be liable to fine. This is with regard to the place of worship. But if your lordship kindly see the contents of the FIR, this is an annexure 1, page number 10. There is nothing like the place of worship. So this particular section is no way applicable.
Oh, circulating false statements.
Exactly. This is no way applicable so far as the section 353(3) is concerned. And the other co-accused has been granted bail. Oh, that's
alarming, this is actually a place of worship because if it triggers
exactly
communal tension,
exactly.
that is why.
But this is not the case of this place of worship. Lordship may consider the contents of the FIR.
Diary is not come, you said. No?
Diary has come, my lord, without the medical report.
Medical report. So let me see. Is it necessary?
Medical report otherwise not required, Lordship.
353. His statement recorded, my lord.
353(3).
Okay,
Lordship can take note of that particular provision of 353(3). There is no ingredient of section 353(3), which is actually the non-bailable section. Others are all bailable sections. And others cooperating with the investigating officer.
Say actually dangerous weapon. Bricks and rods will be dangerous weapon only. So that's why you wanted to see them.
No, the other sections in which the case has been registered, Lordship.
You are on interim. Let us see. Otherwise, it will be like not seeing.
Because the sections which my learned friend is saying about the medical report, because I'm referring to the sections in which the case has been registered. Because all these sections are bailable and only this particular section is non-bailable.
Which is bailable?
All other sections, 351(2), 352, 356, 324 and 1152. Is the criminal intimidation, then defamation, 352, 24, 2 and 1152. These are all bailable sections, except 353(3).
No, no, grievous hurt section. Which is the grievous hurt section?
It is not here.
Not here.
Yes, they have not
There's
registered a case.
allegation of grievous hurt, right? Anyway, let us see the diary. It will not prejudice you. Maybe before vacation.
Short date may be given, lordship is pending for a long period of time.
Next.
He's on interim, my lord.
I can understand the interim.
But the several cases has been fixed, already fixed, my lord.
Anyway, on the day of reopening.
My lord.
First, immediately after reopening.
Yes, my lord.
The case diary is stated to have been received, but without the medical report. And learned additional PP seek some time to procure the medical report. Prayer is allowed.
Then after V vacation, lordship, I'll have some difficulty.
Yes, my lord. No, on 20, my lord.
20.
Case diary may be sent back and returned, procured again with the up-to-date investigation and also the medical report. Interim bail stands extended till the next date of listing. Fixed on 20th
20th of January
20 January. my lord.
20.
My lord.
2026.
Yeah, please, Your Lordship. Actually, the two bail application, one is anticipatory, my lord, another is regular, my lord. And Your Lordship on 24/9/2025, my lord. After perusal of the case diary, my lord, Your Lordship granted interim bail, my lord. Both the cases, my lord. In the medical report, my lord, there is nothing, my lord. That is why, my lord, Your Lordship, in paragraph number 5 and 7, my lord, Your Lordship order, my lord.
He's on interim, my lord. From
Okay. Diary receipt,
Is there not received?
not received.
Not.
Left adjourned. The petitioner was granted interim bail on 24/9/25 and case diary call, which however is not received today. No, case diary was received on earlier occasion.
After perusal of the case diary, my lord, Your
No,
Lordship granted
no,
interim, my lord.
Rakesh, just delete. The updated case diary was called for along with the FSL report. No, FSL report is already there. Updated case diary was called for incorporating the opinion regarding that.
Lordship.
My lord.
However, the same has not been received. Issue reminder. Is the matter of interim bail since granted by the order dated 24/9, 10 next district. Wisdom
21/1/26.
21/1/26. And what about the other one?
35 also same.
Same time, my lord.
Same. This is the regular bill,
Lordship.
24/9. Okay. 21/1.
36.
Must be.
May I please, Your Lordship?
The case diary not received, my lord.
Lordship, I am extremely sorry, Your Lordship. Today is the fourth occasion, Your Lordship. They failed to produce the case diary.
From Thana, who is Thana? Police station.
This is from Sunari, Your Lordship.
Sunari,
Gwalpara district.
Walpara district.
Golpara Sunari.
Sunmari, Sunari. Sunari PR.
Today is the fourth occasion.
The case diary is not received. The learned counsel summates that 4 dates have already lapsed, including today, the case diary. What is the allegation?
Allegations are serious. Plus 13, sorry, 11, Your Lordship. Allegations are serious, Your Lordship, but there is no any specific allegation against the petitioner. And they have been named in the FIR.
So two people died.
2 people died, Your Lordship, but 28 persons name have been made as accused here in Your Lordship. And no specific allegation against the petitioner. So if it is possible, Your Lordship, I am praying for interim, Your Lordship, till production of the case diary.
Multiple deaths.
Yes.
Well, let us see. Okay, but he, please ask him to send it.
My lord.
Why is
On my lord,
the case,
19.
the I was directed to positively send the case diary on the next date
19.
without fail. So stop you want a copy of this order? You want a copy of this order?
No, we may furnish to us, my lord.
Copy of this
It will be
order shall be
helpful.
furnished to the
Otherwise, your lordship, personal appearance may be.
additional public prosecutor. Just keep it open.
1912, my lord.
18. Can it be on 18?
Failing which the court will be constrained to take exception.
Part 7.
18.
May I please, Your Lordship? Your Lordship, I'm appearing on behalf of Mr. P.K. Das, Your Lordship, the learned counsel in this matter,
Yes.
Your Lordship.
Mhm.
Your Lordship, however, due to some personal difficulties, Your Lordship, unforeseen, Your Lordship, he has to leave the premises of the court, Your Lordship. I'm being instructed to take the matter for a pass over for a day, Your Lordship. However, Your Lordship, all the accused petitioners are on interim, Your Lordship, as per order dated 28/10/2020.
Diary has been received.
There is receipt. There is.
They must have appeared.
There.
They have appeared. Just a minute. I'll
Yes, sir.
consider you. Let's wait for his.
Yes, Your Lordship.
When do you want it?
Your Lordship, after a week, Your Lordship, if it's possible and
Next
convenient.
week will be very.
Next week or Friday?
Next Monday.
Next
Next Tuesday.
Next Tuesday. CDB retained?
Would you like to retain?
Yes, but otherwise they have appeared before the Ayodhya. Offense has been given.
But the allegations are.
Yes, fine.
What are the sections? No death, right?
No, Your Lordship, joint criminal liability and Your Lordship, cruelty, Your Lordship.
Cruelty.
On demand of money. Yes, Your Lordship, demand of dowry, Your Lordship, after 10 years of marriage. Persecuted both physically and mentally by the petition.
$85 BNS.
85 BNS. Husband or relative of husband of a woman subjected her to cruelty.
Oh, okay. I think we can dispose it of. 498A.
Yes.
The Allahabad High Court has passed an order. Our youngsters are up to date. Everything they will be knowing. The Allahabad High Court has passed an order that when you file these petitions, along with the BNS sections, also mentioned the earlier IPS. As I read in the media.
May I submit, Your Lordship?
Yes.
Your Lordship, I have.
No, I'll allow it. I'll allow.
My name is not there on the Wakalat number, Your Lordship. Perhaps that is the only issue. Your
The
Lordship.
matter be,
Yes.
should be retained or should
Yes,
it
Your
not
Lordship.
billing of?
Why not? Okay, you are not.
Yes,
in the record.
there might be some predicament, Your Lordship, with respect to the non-appearance of, non-reflection of the advocate names.
You're doing submitting well. Sign. Color.
Yes.
Anyway, it doesn't matter. No issues. Yes, there is received. How about the learned petitioner counsel? Six in adjournment as the leading counsel would not come due to some personal difficulties. Prayer is allowed. Interim bail stands extended in the next date of listing. Is the matter on? How about Thursday? How about Thursday?
Yes. Much obliged, Your Lordship.
Thursday, Lordship, this Thursday?
And this week? Okay, 11. Then it will be easy for you. Investigation.
Much obliged.
11, 12.
Right, please, Your Lordship. I think there are two petitioners, and pursuant to the interim order dated 29/10, we appeared and got our statement recorded locally.
CD was called for, Lordship, petitioners are on interim, Lordship. CD not received.
Case diary is not received. Issue reminder. Interim bail granted by the order dated
29/10.
29/10 stands extended till the next date of listing.
First week of
please stop.
January, Lord,
20.
first week of January.
14.
Yes, Lordship, can it be on
Not
nine,
you only,
9-1?
9-1.
9-1.
Not-
No problem. You suggest.
May I present, Lordship? Lordship, case diary was called for, Lordship.
Lordship, here, the matter has been closed by submitting search sheet, Lordship. Right, CS number 113 dated 30/11/2020.
Lordship, there is an interim, Lordship.
Your good name?
S. Pradhani.
SH Board. Order dated 29/10. Second, third paragraph will be sent. The petitioner was granted interim bail on 29/10/2025. And CD called for learned additional PP submits that investigation is completed in the meantime, resulting in a charge. The given facts and circumstances, and also keeping in mind the completion of investigation, the interim bail granted by so and so is hereby made absolute, subject to the condition that it shall be available for trial if one commences, and shall not hamper or tamper in petition stands allowed in this process.
Obliged, Lordship.
41, Lordship, CD not received. Lordship.
May I please your lordship? Lordship, last time I have argued this case before the Honorable Justice Sanjeev Kumar Sharma. In this case, lordship, what happened, after this filing this petition, my lordship, the petitioner number husband, the accused number one of this case, got statutory bail after completing the 90 days period.
Right.
So their husband and wife, my lordship, so Honorable just asked for produce the document of the bail order. At that day, it was not in my possession, my lordship. So I have collected this document. So may I pass it to the court, and I am not making the case on the merit, my lordship, case there is not receipt. So I am making this case only on this bail order, my lordship. Just ask for me.
That is a regular bail, Lordship. Petitioner is applying for anticipatory bail here, Lordship.
Part time the CD is not received, my lordship. And they are both husband and wife. They will not hamper and tamper any evidence. They will completely cooperate with the investigation authorities, my lordship.
Because
They're from the same household, my lordship.
contents of the FIR reflects that the victim sustained grievous injury, Lordship.
So, my lordship, in the FIR it is stated it's a grievous hurt, but that was treated by the village doctor in the
Who
pharmacist,
happens to
not
be
by
old
the treated by the
lady.
any.
Who happens to be old lady, Lordship. She has
I'll
sustained.
see.
It could have the contributed natural as also, my lordship.
Lordship, give us a last
Number
chance,
of
Lord,
torture.
before vacation any day.
One is mother, mother.
Mother, Lordship.
But that day, my lordship was supposed to grant me the bail because I was not able to produce this bail order, my lordship. He was asked for me to produce this document today. That is why case has been fixed today, my lord.
And subsequently, she died, Lordship.
Died also.
Died after 5 days, the incidents after occurred. Incident occurred on 4th and she died 9. And after that, the case was registered. The FIR was filed, my
All
lordship.
case to
This is
CD along with
you're right, actually. This is a AB on a slightly different
Lordship.
footing.
Yes.
The case diary.
CD along with the postmortem report.
Case diary is not yet received.
Well, the third time, my lordship, case
Learned,
there is.
petitioner counsel seeks bail on the ground that in the meantime, the co-accused Arman Ali, who is the husband of the present petitioner, has been granted statutory bail by the order dated 10/11/2025. The learned court bill. The present petition is the one for anticipatory bail. The case diary.
Lordship, can it be any day before the vacation? Because anytime charge sheet might be filed, lordship.
It is submitted that several dates have elapsed. 2 dates, 3 dates have elapsed. Several dates have elapsed in due to case diary. Case diary shall be procured. List on. You can have
18, Lordship. 18.
18.
Yes.
Deeply obliged, my lord.
42.
May it please your lordship. Lordship, I am on interim in this case. Your lordship, your lordship will find a FIR from page 10, your lordship. Actually, your lordship, there FIR, if your lordship goes on to the through the FIR, I'm going to the vernacular FIR, your lordship. Your lordship will find on page 14. সন্মান পূৰ্বে বিনীত নিবেদন এই যে কাৰণ মোৰ পত্নী শ্ৰীমতী মনালিসা কোচে যোৱা ইংৰাজী 1-10-2025 তাৰিখে ৰাজঘৰস্থিত ইণ্ডিয়ান বেংক বৰব্ৰাম শাখাৰ ওচৰত থকা দীপাংকৰ মহন্তৰ শৰীৰ চৰ্চা কেন্দ্ৰলৈ যোৱা চিৰিত বিহপান কৰি আত্মহত্যা চেষ্টা কৰিছিল। উক্ত দিনাই মই ডিব্ৰুগড় মেডিচিটি চিকিৎসালয়ত ভৰ্তি কৰাওঁ। যোৱাকালি অৰ্থাৎ 3-10-2025 তাৰিখে চিকিৎসালয়ত মৃত্যু হয়। মোৰ পত্নীৰ মোবাইল ফোনটো চোৱাত পাছত গম পালো যে শ্ৰী দীপাংকৰ মহন্তৰ লগত অবৈধ প্ৰেম জনিত সম্পৰ্ক আছিল আৰু উক্ত ঘটনাৰ বাবে দীপাংকৰ মহন্ত আৰু পত্নী ৰুঞ্জুন মহন্তক জগৰীয়া কৰি মোবাইলত আত্মহত্যাৰ টোকা লিখি যায়। So this is the thing, your lordship. I am not Dipankar Mohanto. I am the wife of Dipankar Mohanto, Runjun Mohanto, your lordship. Your lordship, the thing is that, your lordship, being a wife, your lordship, I was when I came to know about it, definitely I will be aggrieved by this. But there was no contact between me and her, your lordship. Now Dipankar Mohanto, who in the interim order has been observed by this honorable court as a main accused. He is also out on bail. He surrendered and he is out on bail. I am on interim bail. I have appeared before the authorities concerned, your lordship. I'm cooperating with the investigation, your lordship. There was no manslaughter, your lordship, on my part. So there is an affair between two persons. I am the third person, your lordship. So I've been simply dragged in this matter.
Yes.
Lordship. Her statement is recorded. From her statement, it reflects that
Yeah. Do I need to see the case diary?
yes, Lordship.
No, not necessary. If you can submit.
Lordship, I'm coming to her.
Sort of time also, and she has a child to look after. Should we make it absolute? We can make it. I mean, order 311. Second paragraph is same, but I will. My own thing. The allegation in the FIR, if it's same thing, is that the wife of the informant committed suicide on the stairs of Dipankar Mohanto's gym, consuming poison, and that later he came to know that she was having illicit relationship with the said person, and there was a note in her mobile phone implicating that person as well as his wife Runjut Mohant, the present petitioner. He was granted interim bail on 3/11/2025, pursuant to which he has appeared for the statement report. The petitioner also has a minor child to look after. The circumstance, the interim bail is hereby made absolute subject to the condition. She shall be available for trial if on comments. She shall not hamper or cancel. Return back.
May please your lordship. Anticipated bail petition, my lord, interim was granted, my lord, and thereafter in two occasion I appeared, but IO is not there in the police stations, and thereafter on 2nd of this month, my lord, I appeared and my statement has been recorded, my lord. Regarding the earlier appearance, I have filed an affidavit, my lord. The FIR.
No problem.
Yes, my lord. Later on I appeared, my lord, and my statement has been recorded, my lord. FIR is at page number 14, my lord. May I read, my lord?
Page 14.
14. Information of death of my daughter Srimati Gangotri Soikia on 11/9/2025. I, Srimati Purobi Soikia, wife of Sri Dulu Soikia, resident of village Katarbari, post office Barangabari, district Biswanath, Assam, would like to inform you that my daughter Srimati Gangotri Soikia is about 28 years
was found hanging on 11/9/2025 at her paying guest accommodation at house number so and so. So the death occurred at 4:30 p.m. on 11/9/2025 at the above mentioned address. She was married to Sri Avinash Hazarika. This is the petitioner, my lord, son of Mukheshwar Hazarika of village Patarbari, Post Office, Barangabari, District Biswanath, by registered marriage on 2025. That they were not staying together and her husband had promised to marry for in wedding to Hindu custom on a future date. That her husband started to torture her by harsh word over telephone or personally whatever they meet, and she has been severely subjected to mental torture and abuse, which finally led her to take the extreme step of suicide. I therefore request you to register a case of abatement of suicide against Sri Avinash Hazarika, her husband, and take necessary steps to prosecute the said person according to law. My lord, it is admitted they are living separately because of their profession, my lord. The deceased wife of the petitioner residing in Guwahati because of her job, and the petitioner was residing at Biswanath as he is a government servant, my lord. And sometime, my lord, some quarrel had happened as a marital life, my lord. And suddenly, my lord, this was happened, and infuriated mother of the deceased, my lord, lost this FIR against me, my lord. And CD is called for, my lord. And I have already cooperated with the investigations. I went to the police stations, my lord.
Please, 108 has been given, PNS abatement. Here for the information.
Lordship, postmortem report received. And the result is death was due to asphyxia as a result of antemortem suicidal hanging. And there are no signs of suggestive of physical abuse and vaginal swab of the deceased was preserved. And
No injuries on our body.
yes, that is not. An oblique of non-continuous ligature mark was found over the neck, high up above the level of thyroid cortex.
My statement has also been recorded, my lord, but it is. আগতে কৈছিলো সেয়া নাছিলে।
Lordship statement not found. Statement
When the 3 days call for, my lord, I don't know. It was second
to 1209.
1209.
Yes.
My lord, in second of
It
this
up
month,
to
my
this
statement has been recorded.
PD along with the statement.
Let it be updated.
Miles.
Case diary has been received, but the statement of the has been received, but it is not sufficiently updated. And statement of the petitioner recorded pursuant to grant of interim also not there. Full stop. The case diary may be returned, procured again with the updated investigation, including the statement of petition.
Continued, my lord.
Interim bail shall continue till the next date of this. Kindly suggest the date.
Lordship, can it be in the after Bihu vacation or before vacation? Any date as per the convenience of the court.
Put it before view.
Okay.
Say the 306.
8 or 9.
8.
Lordship.
Hello.
Case diary was called for.
What call for that we have not received, Lordship.
No,
Kindly suggest us kindly give us a date, Lordship. CD not received.
If there is not received, issue reminder. Is
On
the
19th, my lord. On 19th December, my. I am not in interim.
19th is
Last day.
19th is Saturday.
Oh, my
Sorry.
18th.
Sorry, it is 25th. 19th is Friday.
Right.
Should
We can try on 19.
Huh?
We can try on 19.
19, 12.
19
or no. Right. New method.
CDI.
Update.
I see.
Carry
My lord, in this case, if your lordships look into FIR, the whole contention is a fake doctor. Now we move this matter before this court. Our contention at that relevant time was they have not served notice under 35P of the BNSS.
35.
35.
Arrest memo.
Yes, now 35 was not been served notice following Ernest Kumar judgment and others. So they have to serve a notice. On this ground, an interim order, we showed, man, the interim order was passed by this court, protecting us that whenever a notice is received, till then we should be protected. Now, as per my instruction, my lord, a notice has been served. This notice has been served on me on 29/11/2025. And my statement is recorded, and there is a bond which has been executed and saying whenever you have to come, whenever you have called, you will be called. So I just want to bring an affidavit, all this contention before your lordship. So a time should be given at least 4 or 5 days time so that I can bring it by way of notice, by an affidavit and bringing the record before the court. This is my humble submission, my.
There has been
The case they received, my lord.
written.
My statement also has been
And,
recorded, I don't know.
That statement is not available in the case.
That's
diary.
what I
Your statement along affidavit will contain the statement as well as.
Yes, correct. And my affidavit, I will come up with a small IA that affidavit stating that I have received a notice, statement has been recorded, that bond has been executed.
And my lord, here, why section 35 notice, my lord, not issued? There are specific, my lord, note and regarding the detailed ground, my lord, mentioned by the IO, my lord. Here, I would like to, I attempted service of notice under section 35(3) BNSS at the residence of the accused on 11/11/25 and again on 16/11/25. However, the accused was found absent on both occasions. Family members present refused to accept the notice despite clear explanation of legal provisions under section 35(3) BNSS and guidelines of Honorable Supreme Court. Ernest Kumar versus so and so, a non-service report has been.
Let him file.
But they have served now, they have served, we have appeared.
But learned senior counsel, Vikas, who submits that pursuant to grant of some interim order, the petitioner has appeared and his statement has been recorded. Subsequently, he has also issued a notice whereupon he appeared and a bond was executed with him, directing him to appear as and when required.
Yes.
And that the same is desired to be brought into the record to the additional various law. So the case diary retained, case diary received shall be retained. Interim order, the by order dated 19/11 shall stand extended till the next day. Should we fix it on when? Next Tuesday?
Next year?
Next Tuesday?
My lord, if necessary,
Next
my lord.
Tuesday, my lord, if it is not inconvenient, can it be on Wednesday, my lord? Next Wednesday, 17th?
Because my lord updated regarding his my lord, statement, everything is not available in the
You want to send it back?
my lord, if necessary, my lord. Otherwise, I'll tell your lordship may not record regarding retaining of the case diary.
I won't say. No, nothing regarding retain.
I will talk with the IO, my lord, if necessary.
My lord, 17 and reply.
May please, your lordship. Anticipatory bail petition, my lord, FIR is at page number 17, my lord. And the operational started from page number 18, my lord. May I read, my lord? With reference to the subject cited above, I have the honor to report you that on the basis of reliable information, self-accompanied by one DYSP headquarter Nogan Permita Sarkar APS, second DYSP Tunmani Soikia APS, ISCDSP Roha, DYSP Police Deep Sinha APS, Inspector Biren Kolita OC Dhing PS, WSI Indira Brahma proceeding to the house of accused Raju Ahmed, that is the petitioner, my lord, son of Abdul Rauf of village Haidubi Post Office, Police Station, Botodrova, District Nagaon, was searched in connection with Botodrova PSZD number so and so dated 31/8/2025. During the search, the accused person fled from the spot, leaving behind various incriminating materials. The following items were recovered and seized in presence of independent witnesses, namely so and so, so and so, so and so. 1 HP laptop, 1 16 GB Sony pen drive, 4 mobile phones, 10 stamp seal of the foundation and other related institution, 1 notice of appearance issued by the Bihar Cyber Police Station, Kaimur, 2 bank passport, a passbook, 1 checkbook, 1 debit card, crypto investment form, 1 pink file containing documents of BREM Properties Development Limited, board resolution for opening Batamari Haidobi Royal Foundation. During scrutiny, it has surfaced that Cyber Crime Police Station, Kaimur, Bhabua, Bihar has already registered a case by FIR number so and so dated so and so under section 419, 420 IPC reduced section 66C, 66D IT Act 2000 on the complaint of one Sonu Kumar, son of Audesh Chaudhary, village Bishrampur Police Station, Khudra District, Kaimur, who had been defrauded of rupees 13,50,000, which was credited to the accused account. Further upon verification with ICICI Bank official Sri Nayanjyoti Das, Journal Head, and Sri Mukibur Zaman, branch manager, Nagaon, the following fact came to light. The alleged ICICI Bank statement in the name of MS Abdul Rauf Memorial Foundation, care of Raju Ahmed, is fake. ICICI Bank account consists of 12 digits across India. The seized fake statement mentioned an 18-digit number. ICICI Bank statement never carry customer photographs. However, the fake statement carried both a photo and a QR code. The customer ID so-and-so is genuine and linked to account number so-and-so open at ICICI Bishwanath branch, Bashishta branch, Guwahati under MS Abdul Rauf Memorial Foundation. This account is a saving account with all reliable balance. Now, your lordship, kindly come to page number 20, my lord. This is the next part of the FIR, my lord. The fake 20, page number 20. The fake bank statement mentioned IFSC, ICICI so-and-so, which actually belong to Bandra Kurla branch, Mumbai. Verification of NGOs further revealed Raju Ahmed is running NGOs in the name of Abdul Rauf Memorial Foundation and Raima Global Beyond Gateway Private Limited, whose signboard were found at his residence. Documents such as forged ICICI commitment letter purporting to hold euros so-and-so in deposit at ICICI Bank Singapore were recovered. The letter was verified and confirmed to be fake. Mobile phone data recovered indicates that the accused has been engaged in cyber fraud by doping customers using false ICICI Bank account, documents and assurance. The accused Raju Ahmed and his wife Pakiza Khatun have absconded from their residence since the morning of the search. The accused has been found involved in cheating people by fraudulently impersonating genuine institution, creating false documents, including fake bank statement and misrepresenting fact to induce victim into financial transactions and using digital means to commit cyber fraud for wrongful personal gain. So main allegation is come from the Kaimur case, my lord, when it is said that an complaint has an FIR has been lost, wherein said that 13,50,000 rupees has been defrauded and credited in the bank account of the petitioner. I have when I get the FIR number, I collected a certified copy of the FIR along with the documents annexed with that FIR, my lord. But that FIR does not disclose anything which clearly indicated that I am involved in the crime, and any amount from that person was credited in my bank account. That FIR is at page number 39, my lord. May I read, my lord? 39 page number. It is requested that I, Sonu Kumar, son of Adesh Chaudhary, am a resident of Bishrampur Post Office, Lakhrabad Police Station, Kudra. I received a message on Telegram as task work, and I started with the salary of rupees 11,000. And while I was completing all the tasks between the date of 6 September to 23 September, rupees 13.50 lakhs were taken from me by fraud, and still they are asking for rupees 6.5 lakh. Phone number of some members from company, namely Make My Trip, are as under so and so. None of these are the numbers. None of number is belong to me, my lord. Therefore, I request you to kindly self that appropriate action be taken up. Along with this, my lord, FIR, my lord, the transaction receipt has been annexed, my lord, which when I applied for the certified copy of the FIR, my lord, that were also given to me, which is started from page number 47, my lord. This 56,000 rupees, my lord. Is Sonu Kumar to some diamond, my lord. 48 is again G2 Fish Center, my lord. 49 to Kishan Traders.
From your petitioner, on the petition.
My lord, from my petition. From 47 it is started, my lord. These are the transactions made by Sonu Kumar, my lord, which was annexed with the FIR he lost before the cyber crime branch police station, Kaimur, my lord, from 47. It is 56,000 rupees, my lord. It was credited to one diamond, my lord. Second, in 48, my lord, it was credited to G2 Fish Center, my lord. Again, in 49, my lord, it is Kishan Traders. In 50, my lord, it is Binod Kumar and Traders. In 51, it is Binod Kumar again, my lord. In 52, it is Mr. GET IPTI, Hemant Kumar. Again, 53, my lord, it was to MS Shivalik Enterprises. And 54, it is Sajidul Haq, my lord. And 55, it is MS, the Export Haq.
Okay.
So these are the, my lord. So not a single, they indicate that 13,50,000 rupees has been credited in my account, my lord. And my account is open to verify, my lord. And I am ready to cooperate with the investigation, my lord. Let the police verified, my lord, everything, my lord. I will cooperate with the investigation. And that apart the sections which are incorporated, all are below 7 Below 7 years, no notice has been served to me by the Batotoba police station, my lord. I am ready to appear, my lord. Yes.
Caesar list.
Yes,
Mhm.
Caesar list, we have,
Caesar list is there.
that is,
Yes.
Lordship may go through.
What was the habeas corpus? The
Oh, that is filed, my lord. What happened, my lord? Suddenly, the police raided my residence, my lord, and without any warrant or without signing any reasons, a police team was my lord, deployed in my residence, my lord, for 24-hour surveillance. Therefore, my brother filed a writ petition before this honorable court because we were living in a joint house, my lord.
He's an accused in on cyber crime of Bihar.
Lordship.
Cyber police station case of Bihar.
Yes, Lordship. Another case is in.
Notice was found. What could you know? Can you submit whatever you
Lordship,
you could read?
on the basis of a secret reliable information, the informant who happens to be the OC of Batotura PS Lordship, he has made a house conduct search of the present petitioner, and they have recovered and seized in presence of independent witnesses one HP laptop, 116 GB Sony pen drive, 4 mobile phones, and all the seized documents along with the materials has been sent to forensic lordship, and that for verification whether these are authentic lordship, because the allegation of the contents of the FIR depicts that he has found involved in cheating people by fraudulent impersonating genuine instructions, creating false documents, including fake bank statements, misappropriated.
What is the
all the
exact
allegations?
What is the exact allegation that
He has misappropriated sum of rupees of 13 lakhs.
50,000, that is the main allegation.
That is the allegations. On the basis of the reliable information, police has made a search at the house of the petitioner and recovered and seized many unwarranted documents along with some gazette office. And those has been those materials along with the documents that has been sent to FSA for verification whether these are fake or genuine. Investigation is still going on. It is in progress.
Everything has already been seized, my lord. Investigation is going on, my lord, and so far the allegation of
Everything
13,50,000.
Fake because the
13,50,000
chit fund lordship.
and 13,50,000 rupees, my lord. I have just take your lordship's kind attention to the
They
FIR,
have
my lord.
impersonating genuine institutions fraudulently lordship by thereby creating false documents, including fake bank statements, misrepresenting facts of victims, for attracting customers from financial institutions. On the basis of fake statements, on the basis of fake documents, fake account number, everything is fake. So that. That is required.
We'll wait for some time.
We need the updated city law.
In the meantime,
That
interim
verification
inspection
report is not
verification, my lord, I will cooperate with the
It's not a
inspection.
case for
It's not a
interim.
fit case law. It's not a fit case law. Confidential.
The case diary has been received, but which Bora, the learned additional PP submits that. Can you just repeat that? What is necessary? The report.
Lordship report. All the documents has been, documents along with the seized materials has been sent to FSL. So that verification report is.
The seized documents, many of which are suspected to be fake, have been sent to the FSL for verification, and that's it. Verification report is awaited, and that same may be necessary. And full stop. The CD may be the case diary may accordingly be sent back and procured again with updated investigation, including the report.
Lordship kindly peruse the last note of that and actual copy note.
Last note.
Yes.
Mhm.
Along with the status report may be called for lordship.
A status report, the investigation may also be called. If it causes delay, then I would say that.
Lordship.
I will only say the status report will call.
Yes, lordship, regarding the
When do you propose date?
lordship, lordship, can it be on 5th of January?
I have no problem.
If come up,
Yes.
my lord, then I have no,
Six.
otherwise, again, if.
No, since you are not on interim.
Again, need to be
Because
election,
it's
lord.
only 1 week left.
He has accommodated.
And that's why, my lord.
5-1. I'll take a short break.
Lordship.
I'm feeling. Gentleman has been waiting actually for this
Lord.
morning. The matter was fixed at 2. But
Lordship.
the bails were there, so I wanted to complete the bails. So
Lordship.
I
So-
requested him to wait.
Lordship, subject to correction, lordship, whether time will permit. Lordship, because
But I know it's a new matter, right?
Lordship,
No, I fixed it at 2. That's why we sought accommodation from him.
because of.
I thought
possible
half
of-
an hour will do. You have another matter?
Yes,
Sir, Doctor?
52. This may not be possible today's hearing.
This was actually not been able to complete the list.
Is the IF of a alternation of the lordship's order.
Mhm.
That is the. That is the
What
case.
I propose, my lord,
Typographical error?
no,
Not that.
First, for vacating of the stay, they have filed an application
Vacating of
of the interim, yes. What I propose, my lord, the matter may be on the, after the view vacation, and in the admission stage, because in the order, perhaps, yes.
My lord, this is the IA, my lord. Necessarily, it will come in the orders column.
Mhm.
My lord, my contention is that, my lord, first my IA may be heard. Thereafter, my lord, the main case may be heard.
It will be futile exercise. The entire matter will go.
Yeah,
Let
that
the entire
definitely,
matter
my
be heard, my lord.
Because without going into the file, I cannot.
Yes.
Yes,
To guide me.
On 28th of
Today,
January, my
paucity
lord,
of
I'll
time.
be here.
Paucity of time.
28.
8.
28, no. I got that.
Too long.
28 level.
And the Kali law, if it is possible, tomorrow may be fixed. I am outstanding lawyer, everybody knows.
But I can fix it, but it does not reach. That's the problem.
I
Unless
will
we upgrade it.
again then to get time. On 27 and 28, I'll be here.
Any date, my lord, it is on 20. Because on 25, I will not available, my lord. This is
25
25 of
Okay.
25 of this month. Holiday.
No, 25 of January.
January.
Actually,
He is
Then on 19th or 20th.
on 90 or 20, that is suitable, my lord.
On 19th.
I have to accompany my son, my lord.
No, no, no. it should- 19
This
was
is my personal difficulties, my lord. He definitely he has some personal, he is the outsider.
No problem. I will not quarrel with this.
Yes,
19 and 20 I propose.
yes, yes.
So why you quarrel?
19, 20,
19.
19.
19, 19.
My lord, item number
26, lord.
51, my lord.
19.
Item number 61. Maybe my lord, any other date, my lord.
61.
51. My lord, in that matter, interim may be continued. 52.
Interim shall continue.
Regarding 51
My lord, 51, that interim is there, may be continued, my lord.
Can it be also for final
Roba.
disposal after loss due vacation? Without loss, it's still the submission loss. I'm just vacating the stay order they have got from this court law.
This also you fix it, then, other one we had fixed it 19, right? 19, no? 20, 20, 20, 20, or 22 we want. 22/1/2020. Interim shall continue. 51, right?
Well,
Item number 50,
50.
50, they actually this matter.
Delay condonation.
Delay condemnation was there, service has not come for the last 2-3 months. The person is stuck. It's only 3 years conviction. So if it can be taken up sometime next week. And if they don't appear, then we can always, your lordship can appoint an amicus.
Service, where is it stuck? Notice has been sent.
Yes, has been sent by the, through the OC, but no report has.
Can you take instructions? Can you take the instructions so that we can proceed? No,
then-
whatever it is should be decided.
Let it be any day.
50, the prosecution shall take instructions regarding service upon private response. List on before the vacation. Next Tuesday?
Yes, lordship.
Next day.
May please, your lordship, the item 65, lordship. Can it be fixed on 11, lordship? 2000, delay of condonation. Lordship, there,
On 11.
11,
We'll fix it, but I don't know whether it will reach or not. Okay. 11.
11.
My lord,
5:50 of time. Your same method.
no, my lord, item number 5,
Admission.
admission, my lord. Finally, madam, it may be taken after Bihu vacation.
Paucity of time. List the matter in January after the BU vacation to be on a date to be fixed by registry.
Interim may be continued.
Interim shall continue. Let the registry fix a date. You can tell suggested date or
Wait,
that you
wait,
can,
my lord,
otherwise you mention
21, my lord. 21 January.
21 January. Yeah, will be a possible date. 21 January. Item 5. 21 January.
May it please, lordship, in regards to item number 7, which is admission matter, may it be a date fixed before vacation, lordship, it's admission matter. Other person, opposite counsel is here, lordship.
I'm for the respondent, Lord. Respondent number 2.
Any date prior to vacation.
After vacation. List in the month. Can I say like that? List in the month of January.
First week of, date may be fixed, any date, first week.
How about after view? Because I don't know what is the matter. Any
Yeah,
urgent?
it's
If
a-
there's,
it may
there's no,
be
if there's no,
17,
pre-
18 lordship.
if there is no pressing urgency, then after
17, 18,
take it after view.
17, 18, because 19 to 25.
17 is Saturday.
It's a-
Saturday.
It's 9, it's
19,
your 9th or 28 lapses. Because otherwise, 20.
28 to 8. Huh?
Lordship.
Any interim?
No.
No.
Diploma.
Item number 58, Doctor. With the consent of the other side, this matter may be taken up on 19th of this.
Just a minute. Item
19, 58 of the supply list.
19th is the last date actually. A lot of new matters also come sometimes. Okay. You want it on 19th or little earlier? Little earlier you want?
Learned senior counsel, preoccupied on.
Okay, you're for the petitioner.
I'm for respondent number 4.
So 19th is okay for you?
Yes.
Paucity of time 19th.
Lordship, in this matter, respondent number 4 to 6 has filed additional affidavit that is not on record.
Additional affidavit will be brought to it.
May it please, your lordship. Lordship, we take to item number 54, lordship, the last item of the daily list, lordship. Matter may not be heard today because
That is
of
a hearing.
Yes, lordship.
So Lordship, my humble prayer will be Lordship, let it be in the first week of February, Lordship, if possible, because Lordship, on next week, Lordship, there will be a rush because of the motion week. And in the month of January, Lordship, there are so many holidays, Lordship. Before we will be there will be rush.
You are for respondent.
Yes,
Yes,
Your
tell
Lordship. Your Lordship, can it be fixed in January itself? Because it's a matter, two consecutive matters are there. The one is pending in the trial court and this is pending here.
Yes, that you're right.
It's a conviction matter, Your
The
Lordship.
conviction matter.
Yes, Your
It's,
Lordship.
I think, let's take it in the later part of January. Say,
Yes, Your
Lordship. Yes. And you can suggest a date. Why don't you talk and suggest a date?
Can it be fixed on 19 January if possible?
Lordship, 19th January, immediately after BU vacation, it will be reopened. Again, there will be a rush, Lordship. Because Lordship, after 1 week holiday, Lordship, there were so many cases will be filed.
20, how about 27 January?
Okay, Lordship. Or 28.
27 is
Okay. Okay, Lordship. And Lordship, interim order is there, Lordship.
Interim shall stand extended next date of this.
Paucity of time that may be required.
Positive.
Deeply
obliged.
obliged.
You are just completing this case, right?
Lordship, I am to reply in 799.
Yes.
Lordship,
Let's complete that.
Lordship, just a small indulgence. IA 799 and 655,
Mhm.
both from the same FIR and both same grounds for cancellation.
Mhm.
So, because we are running short of time, if I can touch upon 665, the counsel is there. I can make a single reply which will be sufficient in both the cases. So we can complete two IAs at the same time. If my lords agree. Because I will make a reply in 799 and again in 665. It will be a time consuming factor.
Give me a good name. Forward. Huh? Huh? No. Good. Jao. Forward. This is the challenge we are facing, the matters, how to make them reach, how to make hearing matters list. We have to, capacity building is, of course, that is always there. But within
Lordship,
the existing resources, how to
no, I have been seeing
ensure that,
how lords have been trying to accommodate everybody.
it's our duty.
Lordship, it's like this 799 is complete, a reply is awaited, we complete 665, as well as 195 will also be completed with this. So if I get some time tomorrow, a reply and 3 IAs will be closed at the same time, Lordship. Then we will have only the criminal petition and an IA pending in that.
So now we are hearing 799.
We are hearing 665, Lordship.
665.
Lord.
799 is complete.
Only my reply is awaited. And I will be giving a single reply in both the cases because both enumerate from the same FIR and the grounds for cancellation of bail sought is the same. Lord.
Now I take up 665.
Lord.
Right.
Then or 15 minutes. Then what he said.
Yes.
Lordship, as my lords have heard me in IS 799, the excavators were given to a person who misappropriated them. Now the respondent number 2 here is the person who received the excavator. If my lords can kindly come to page 65, which is his first anticipatory bail application.
Right.
Lordships can kindly come to page 68. The first para. That the accused petitioners most respectfully beg to state that they are totally innocent and in no way connected with the alleged offense, and they are not even named as an accused in the FIR. The main accused in the FIR is Tagung Neri, the son of Neri. Now, Lordship, when this FIR is filed, we again get a whiff that this person has filed a anticipatory bail petition. So we enter appearance here and we get a status report from Sejusa police station that the respondent number 2 had one excavator in his capacity. We bring it to the notice of this honorable court and his bail is rejected by order dated 19/8/19. We can have it on page 81, Lordship. The last paragraph, Lordship, on page 82. So far, the petitioner number 1, Sri Manoj Kumar Bora, is concerned, there is some material of his receiving at least one of the excavators involved in this case, and he is alleged by the informant to have started selling some parts of the said excavator, causing extensive damage to it. He is alleged to have received the excavator from the accused named in the FIR. Although there is no agreement between the FIR named accused and the informant as to handing over the excavator to anyone else. That being so, it appears that there is necessity of thorough and extensive investigation necessitating his custodial interrogation, and accordingly his prayer is rejected. Lords will kindly note the observation that his custodial interrogation is necessary and he is rejected, but he is not taken into custody, Lordship.
Okay.
Now, in the FIR, Lordship, all the details of the excavators are mentioned, and when he files this particular application before this court, he files a certified copy of the FIR. Now that FIR discloses all the 4 excavators that have been misappropriated. Having knowledge of the details of the excavator mentioned in the FIR, he still says that no, I am nothing to do with this and I am not named in the FIR. But we gather evidence that he has one. And on the basis of suppression of fact, the bail is rejected outright. To be taken into custody but not taken. He files a subsequent FIR after 3 months, Lordship. Subsequent bail petition with this honorable court after 3 months, which is on page 83, Lordship.
83.
83. The second bail application before this honorable court. Now, my lords can kindly come to page 85, para 4. Page 85, para 4, Lords.
Okay. I'm on para.
Lordship. That the petitioner begs to state that after lodging of the FIR, the petitioner preferred a bail application for granting pre-arrest bail before this honorable court along with Mr. Robi M being such and such, but the same was rejected against the present petitioner wide order dated 19/8/19 on the ground that he has received one excavator involved in the said case. Lordship, in the first petition, he says, I have got nothing to do. Now he admits that I have got one out of the 4 after the rejection of the first petition. Now the next paragraph, Lordship, clearly indicates his malified intention. Para 5, that the petitioner begs to state that at the time of filing of the bail application, the engaged counsel, he is putting the blame on his counsel. The engaged counsel did not mention any statement regarding the receipt of the excavators as involved in the case. Now, he says, I am innocent. My counsel did not disclose that I had one excavator. Up to this, Lordship, it is fine. We did not get a whiff of this application before this court, and he is granted bail. Now, what fine
Say the subsequent bill application.
Yeah, Lordship, we did not know that he has filed one because we were awaiting his custody.
It was allowed on.
It was allowed on Lordship.
On 14/11.
Lordship, page 118 and 119, Lordship.
Just a minute.
Page 118, Lordship, the last paragraph. It appears from the materials in the case diary that the petitioner purchased the excavator involved in this case from one Karken Gomdir for 35 lakhs. The excavator has already been recovered during investigation. The petitioner at best be said to have received the stolen property, attracting prima facie, section 411 of IPC, and the usual terms and conditions. Now, Lordship, what blunder this accused did? If we count our excavators as 1, 2, 3, 4, when the first bail petition was rejected, we have the knowledge and proof that he had excavator number 3 in his custody. Now here, he files the details of excavator number 4. I get to know of this bail after it has been granted.
Excavator 4.
4. Lordship can kindly come to page 46 and 46 of the petition, Lordship. It is a status report by the OC Sejusa PS.
46.
Lordship. This is a typed copy, Lordship.
Yeah.
The fourth paragraph, Lordship. During investigation, it is brought to light that on 15/12/17, Karken Gomdir, son of such and such, made an agreement of mortgage at notary government of Assam with Manoj Kumar Bora, son of such and such. As per mortgage, Mr. Karken Gomdir handed over excavator number such and such for a mortgage value of 15 lakhs. When the first bail petition is rejected, we have evidence that he had on mortgage one of my excavators for 15 lakhs. Now he comes to the court saying, yes, I made a statement, but my counsel did not. I have one, but that 15 lakh story is gone, Lordship. Now he says that I purchased one for 35 lakhs and he attaches the proof of the same. As per my duty, I file a case in Datasil PS for fraud in this court. He is charge sheeted, cognizance taken. The best part that of post bail conduct is that he is not appearing before the courts and he is under warrants for the last 1.5 years. Now, when I come before my lords praying
Despite
for
getting anticipatory bail.
Lordship, I have got the certified copies even of the orders. I procured it today morning. Even the summons through SP Biswanath remained unserved, Lordship. And the warrants are pending against him for the last 1.5 years, Lordship. I will be presenting the actual certified copies. Just today morning I received. Now, Lordship, when it is found that he is playing fraud on this court, first he says, I have got nothing. Secondly, he says, I have one. Now we have proof that he has got 2. We file a petition under 439 subsection 2 for cancellation of his bail. The accused or the respondent number 2 enters appearance, praying for filing an affidavit in the said case to bring his own cause. Now, Lordships can kindly come to the affidavit. The affidavit says on para 1 of the first page.
Where can I find affidavit?
Lordship, the affidavit must be in
another file.
133, Lordship. It must be the running page.
Running.
Because they have 5.
Let it be running page only. Here. Yes. Yes, sir. Don't worry. 136.
Lordship, the first paragraph, he says, I preferred an anticipatory bail application, whereas it was the second application, Lordship. Then Lordship may kindly come to the last 3 lines of the first paragraph on page 2. After completion of the investigation, the concerned IO submitted a final report before CGM Dibrugarh. Now, in this context, Lordship, a report was called from SP Dibrugarh that whether the Dibrugarh PS case 442 of 18 remain pending or it has been submitted as a FIR, final report, which I brought to my Lord's notice on the last date. The case remains pending for the last 7.5 years. Now, Lordship, if I can kindly take my Lords to paragraph 3, that as to the statements made in para such and such, the applicant made serious allegations to me, which I categorically deny and beg to state that I bona fide entered into 2 agreements. In first anticipatory bail, you have nothing. In second, you have 1. Now in your affidavit, you say I have 2. In 2 agreements with 1 Karken Gomdir against 2 earth moving equipments, 676 and 797. Lordships, that opportunity of filing an affidavit to the respondent number 2 was given by this honorable court on 2 grounds. He said that I am a bona fide purchaser. So this court wanted to see that when you paid 35 lakhs and 15, total 50 lakhs, which is a capital payment, whether you have some payment proof of it or not. A purchase of 50 lakhs needs to be paid through GST also, that you paid or not. You acquired a capital item, it features in your income tax return or not. More particularly, you paid 50 lakhs and somebody cheated you. So did you take some steps against him by filing a civil case for recovery of your money as well as cheating, that he cheated you with somebody else's records? Nothing was found. Furthermore, Lordship, the agreements that he has annexed are of 2017. The FIR was filed in 2018 and he has come to this court in 2019. So full 2 years he was using my excavators. Excavators work outside our home, carrying third-party liability and surrounding area liability. So they should have insurance. This court also asked him, fine, we give you discounts on each count. So you bought it like your own. You transferred it in your own. You must have taken insurance. Because if it hits somebody, it has to be taken care of. Nothing. He has got nothing. Lordship, he has played fraud here. It was rejected. The second was allowed because I was not here. Even in the Itanagar bench, Lordship, I will be placing the judgment. His bail has been rejected for suppression of fact by this honorable court. What trend is being set up, Lordship? A 41A notice is issued by the police is utmost good faith that please come and cooperate. They rush to this court for bail. There cannot be any smoke without fire, Lordship. If this person was innocent, he would have joined hands with me that let us come and get into a fight together, that this person has cheated me for 50 lakhs. We should go against him. The third page of this affidavit, Lordship, he says, engaged in my construction site. So when you are working this machine, you need insurance. Where is the insurance policy for the 17, 18 and 19? 3 consecutive years your excavator was in your custody. Now, Lordship, the 4th paragraph. He says there is a case in Sejusa where the first excavator was seized and I have no knowledge. Lordship, he has taken anticipatory bail from Itanagar bench. I have the order copies. The case has been charge sheeted, cognizance taken, warrant issued against him. He is not appearing there also. I will be producing the bail records of that.
But statement here is that he has no knowledge.
No knowledge. I have the bail copies, Lordship. Bail orders and thereafter cognizance taken after charge sheet submission. He is absconding. Warrants against him. I have the copy of the trial court also. Then my lords can kindly come to page 4 of his affidavit in opposition, lordship.
Page
To
136.
maybe, lordship. Actually, they have not given me a running page.
You read the, then I can make.
Lordship,
Para 6.
Para 6. That as to the statement made in para such and such, I categorically deny.
41 to 45.
Lordship,
Para, as to the statements made in paras 41 to 45.
I categorically deny the allegations leveled against me and beg to state that I have never violated any terms and conditions as mentioned in the order that is such and such. Soon after received the certified copy, I immediately appeared before the IO to assist the investigation. No, you again went to District Judge Kamrup Metro with a bail petition. And after the bail, you came to this police station. Now, lordship, they use a very vital term in their bail application that if the lords grant me bail, I will cooperate in investigation. So in case you are not granted bail, you will not cooperate in investigation. That becomes your fundamental right to deceive this court. Okay. Now, then he says, lordship, all the documents and both the deeds were repeatedly mentioned in the application of the applicant. Where did he mention, lordship? Now, Mr. Counsel is appearing for respondent number 2, lordship. Just a small note. I don't find his name in the cause list. I find the name of one Mr. J. Dalam and one S. Nazneen. But he is neither of both. Tomorrow he will come and say, I had not engaged him. He will disown everything. Now, lordships can kindly allow the respondent number 2 to make his submission. So I will make a joint reply in both the matters. That will save a lot of time.
Tomorrow you will.
I will. If he wants to make a submission, he can complete now. So the reply can be tomorrow.
Can you make the submission?
Tomorrow, man.
Late.
Tomorrow or any other date, man.
Tomorrow, lordship can fix at 2. We will complete these 3 IAs altogether, lordship.
But I don't know the list. Has the list come? Has the list come? Okay, just give me.
Lordship, I missed a vital point. Can lords allow me 2 more minutes, lordship? Lordship, can I take my lords to the cognizance order?
Page.
(127), lordship. A beautifully drafted order, lordship. Very seldom we come across such beautifully drafted orders by the trial court. Because this order takes care of the apprehensions in 799 also.
Page 128.
129, lordship.
29.
Lordship. May I read, lordship? Because these 3 pages will clear the air over a lot of matters in the case. Today was fixed for hearing, no objection. I have heard the learned assistant PP. This is a case charge sheeted under section 199, 200, 465, 468 and 471 of the Indian Penal Code against accused Manoj Kumar Bora. The question that confronts me is whether this court can take cognizance of the offences under section 199, 200, 477 or 471 of the IPC on the basis of charge sheet. Before proceeding any further, I may point out that section 190 Code of Criminal Procedure 1973 uses the expression may. Therefore, this court has the discretion to take or not to take cognizance. In that backdrop, let me now visit section 195 CRPC. It lays down that before taking cognizance of offences under section 199, 200, 471 of the IPC, a court must see that the following conditions are fulfilled. That there has to be a complaint. Second, such complaint has to be by the officer whose order has been violated. Complaint is defined in section 2D of the Code of Criminal Procedure and it explicitly excludes a police report. In view of the same, it is not possible on the court's part to take cognizance of the offences under section 199 and 200 of the IPC on the basis of the charge sheet file. Reliance has been placed on the decision of the Honorable Supreme Court in Madhu Limai and others, 1969 1 SCC 292, in a 3-judges bench. So far as the question of cognizance of the offences under section 471 of the IPC is concerned, the position has been clearly settled by the Constitution bench of the Honorable Supreme Court in the case of Iqbal Singh Marba, which I enumerated on the last day, Lordship. May I read the balance para, Lordship?
Yeah, I've gone through. So
Now-
charge was, cognizance was taken on these.
Now, Lordship, the last
465, 468, 471.
Lordship, the last two pages are very important. Reverting back to the facts of the present case, the informant has alleged that accused Manoj Kumar Bora has submitted fraudulent deed of agreement for sale before the Honorable Guwahati High Court while filing anticipatory bills 3239, the second one. As alleged, forgery of the deed of agreement for sale was committed far outside the presence of the court, much before its production in the court. The bar under 195 1B2 would not be attracted and a private complaint is maintainable. In view of the discussions around, the cognizance could not be taken for offences under section 199 and 200 IPC in view of the embargo under 195B1 of the CRPC. However, it does not debar the public servant from filing a complaint before this court under sections 199 and 200. Now, this is the basis of my IA Lordship 195. That this court handed over a copy of this order to Registrar Vigilance of this court as well as SP Dibrugarh. That look, 199 and 200, I am not taking cognizance. It can be through the complaint of a public servant. I am serving you a copy of this. In that IA Lordship, I am just praying that whether they have taken any steps in that regard or not.
Anyway, regarding your, you have to have a reply. So because we cannot, list is not coming. It's not come.
Lordships can kindly come take it tomorrow because he replies and I will complete all the three IA Lordships.
Are you okay with tomorrow?
Lord, I am.
Very nice. It's okay, accommodating you.
I will be highly obliged.
Approximately how, can you do it within half an hour? Tomorrow? Will it be
Well,
possible? Your part?
Well,
Then should we fix it at 2? Huh? Very difficult. Hmm? No, not 2 is not difficult. I'm managing the matters.
Lordship, we will be
Tomorrow-
present at 2 at any time after 2, Lordship.
No.
We will not be hard and
Well,
fast.
Tomorrow, sometimes the daily list is less, but tentatively at 2.
Lordship.
Tentatively at 2. 54 matters. Hearing day. We'll keep it at 2, then we'll see what can be done.
then my lord, if not no problem, then it's day after tomorrow.
Day after
Let us keep
tomorrow,
it
it will
tomorrow.
be
If
even
not,
lo-
which we will have
even
to
more
do
longer.
day after
My
tomorrow.
lord.
It'll be 64 matters outside.
Lords,
Capacity building.
I have been able to lay on a judgment Lordship had asked me where bail had been cancelled for forgery in court.
You can submit. High Court, Supreme Court.
Supreme Court, Honorable Justice D.Y. Chandra.
Fraud, vicious, everything, if fraud is proved.
Now, Lordship, in that particular case,
Anything that helps you, or you can also find whatever judgment helps you. So we keep it for tomorrow.
at 2.
Obliged.
Ordered.